Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and its honorable court.
Good morning. Well, we'll ask counsel if your case is not up, please turn off your video. Thank you. Mr. Milling, you may proceed.
Sir, Your Honor. Morning, Your Honors. May it please the court. My name is Jonathan Milling, and I'm proud to be here today before you representing Tacoa Glover. In our efforts to vindicate a Sixth Amendment violation of his right to counsel, not once, not twice, but three times in this case. And you may think three times, we've only got two different issues on appeal, but really his violation of his right to counsel started as soon as he was arrested, when his family chose to retain counsel out of Atlanta, Mr. Weintraub. And shortly after that, shortly after he received funds to retain his services, deposited those funds into a bank account and chose to turn those over to the DEA. He chose to write a check, and the DEA kept those funds, thereby depriving Mr. Glover of the ability to secure counsel of his choosing. Before Mr. Glover even got to district court, before he was appointed counsel, he began to start requesting the return of those funds. He invoked his right to counsel of his choosing under the Sixth Amendment, under Lewis versus United States, to be able to have access to those funds, to be able to hire counsel of his choosing. He was never, not then, not a month later, but he was never given the opportunity to present facts to the district court to be able to show why he should be allowed to get those funds back to hire counsel of his choosing. These were funds that came directly from the lawyer's bank account. There was no authority for the DEA to be able to seize those funds or maintain those funds, and the government, even in their responses to the district court and the responses to the motions for the return of the funds, acknowledged that they could not have seized these funds in the first instance. If we look at the forfeiture statutes, there was no authority that was granted to the DEA, to the government, to be able to seize these funds or maintain these funds. And frankly, they should have been returned, but there was not an opportunity that was given to Mr. Glover to be able to do that. He was deprived of his right to counsel of his choosing, a structural error which pervaded the entire process here with the district court. He screamed at
counsel. Counsel, if I assume that is correct right now, that was improper, does the Sixth Amendment issues that exist pre-plea, how does our Moussaoui case not constitute an event that intervenes from a causation standpoint and constitutes a waiver of those issues? I understand your arguments and have some substantive aspects, but how does Moussaoui not block that argument for pre-plea issues?
Your Honor, I would just submit that because the structural problem here with the Sixth Amendment really pervades the relationship that Mr. Glover had with his two appointed counsel, and during most of the process, Mr. Ailes, he did not have that guiding hand that the Sixth Amendment guarantees. He did not have confidence in the process. He did not have the ability to really work with a lawyer throughout the process. And so,
okay, Mr. Milling, excuse me, Mr. Milling, 1 second. You know, as in preparing for this case, I'm very sympathetic to your argument, but what I'm really having trouble with is what Judge Quattlebaum has alluded to, because in Moussaoui, we rejected the premise that this was a structural error. We said specifically that we did not agree with the Ninth Circuit in Hernandez, and we said that it was a faulty premise because it fails to account for the fact that if the defendant proceeded to trial and was convicted, he could seek an appellate remedy for the constitutional violation. So I'm worried because I think you make a really good point, but I'm really worried that Moussaoui boxes us in. It says the structural error analysis is a faulty premise. So how do we deal with that?
Your Honor, I think that we would have to look to other cases and look to the individual facts of this particular case, because since my client tried from the beginning, from the outset, to have this opportunity, he tried in earnest at every step of the way to really be able to bring this to a head and have a decision. I think the fact that we don't even have a hearing really gets us back to where a lot of the error is. He had no opportunity to be able to enunciate to the district court why the issue was there, why he was having a problem.
I agree with you completely. I agree with you totally. I'm just worried that maybe we have to go in bank here in order to deal with the Moussaoui rejection of structural error. That's just what I'm wondering.
Yes, Your Honor, and that may be ultimately where we end up in this case, to be able to truly vindicate Mr. Glover's rights. Because as we look at Lewis, as we look at Boya Gomez, frankly, as we look at Farmer, we've got a situation where there is no evidence in the record showing that these were tainted assets. The only evidence that we've got is Mr. Glover's representation that these were not tainted assets. And so not having a hearing deprived a full evidentiary opportunity to determine exactly what happened here. And it gets us to not just the Sixth Amendment, but as Farmer outlined, it was a due process violation. And so, he did not have that opportunity. And the timing of it also really gets into play because, if you don't have a lawyer from the get-go that you're working with to give you that counsel, to give you that guidance, you really lose the opportunity to know what's going on. You lose the opportunity under the Sixth Amendment to have that guidance of a lawyer. And that's really where the problem arises here. And it doesn't just arise from the outset, from the totality of the case, but we see it really at the end when he moves to withdraw the plea within a month of having to plead guilty. He was given a choice. You plead guilty under these circumstances, or we're going to trial, and we'll have the hearing after that. The judge.
Mr. Milling, I'm glad. I wanted to ask you a question about that part of the a part of your case.
Yes, sir.
On the let me ask it this way. I think if you look at the record, the district court decides the motions that were heard in October of 19, and he really kind of, aside from some preliminary issues, talks about motion for substituted counsel and motion to withdraw, and doesn't, in a discrete way address the conflict-free counsel issue. Now, we could question whether that was framed that discreetly, but regardless, that's not separated as an analysis. He talks about the coercion really in the more discussion. But here's my question. Does the district court, if presented with allegations that, if true, would create a conflict, does the district court have the ability to look at the record as a whole and say that those allegations are not credible based on the record as a whole? Is that within the district court's authority?
Your Honor, I think while the district court may have some authority to look at the totality of the circumstances, the record as a whole, and the framework that got us from point A to point B, I think it's incumbent upon the district court, upon those allegations being raised, to make sure that the client, that the defendant has a lawyer to advocate on his behalf to present those facts. We've got a situation.
So if I could just interrupt, I apologize for that. So as I think I understand what you're saying, if the allegations, if true or credible, you think at that point, hard stop, you get a new lawyer. Is that right?
Yes, sir. Even if that lawyer is limited to representing the individual during that particular proceeding, the allegations in this case were very pointed against Mr. Ailey's, his trial counsel, and at a minimum, we needed a lawyer to be able to step in to ask questions of Mr. Ailey's, put him under oath like we would in a normal 2255 situation.
So a district court then can't do what happened here, admittedly, maybe under more, but assume that he had said, now let's talk about conflict-free counsel. I want to take evidence, and based on what I've heard and based on your client's, quite frankly, history of less than forthright representations, I find that the allegations are not credible. The district court can't do that without appointing a separate lawyer. Is that your position?
That's my position, Your Honor, because Mr. Glover didn't have somebody to advocate on his behalf. He did not have anybody representing his interests. And as the First Circuit has found, this is a situation where it is an essential part of the process to which he is entitled to counsel. He needed somebody to be able to represent him in the motion to withdraw the plea, and he didn't have that. He made it very clear with the district court, I don't want to represent myself. I want a lawyer to represent me in this proceeding. If he had said, I'm going to represent myself, then a Faretta warning would have been required. It wasn't given, but instead he was left in this never land where he's got a lawyer against whom he's made allegations, who is given the opportunity to either fall on the sword and say, yes, this happened. I wasn't ready for trial. I wasn't ready for any motion hearings. I haven't subpoenaed any witnesses. I don't have any evidence, any experts on cell phone triangulation or canine experts. I haven't talked to any impeachment witnesses. But instead he says, I didn't endorse this motion. I don't think it's in his best interest. I don't see how that can be any further from advocating on behalf of your client. He chose self-preservation over representation of the client, and that's really where the conflict arises, and that's why Mr. Glover was left without counsel. He had nobody representing his interest, and so that's where really that second issue of the denial of the right to counsel comes into play here. He did not have anybody advocating on his behalf, anybody to talk through the more factors, anybody to really get into the sum and substance of these issues.
Okay, so what you're saying then, Mr. Milling, is that if we're forced to reject your argument that there was a structural error because of Moussaoui, we could nevertheless reverse on the basis that he was denied counsel?
Absolutely, Your Honor.
Okay.
Absolutely. And I see that I'm out of time. I've got, I think, 7 minutes reserved for rebuttal, and I'll be happy to answer any other questions at that time. Thank you, Your Honor.
Thank you, Mr. Milling. Mr. Gant.
May it please the court, my name is Addison Gant, and I'm here on behalf of the United States. This court should affirm the district court for two reasons. One, because regardless of whether Glover waived his right to contest the administrative forfeiture process, the district court lacked subject matter jurisdiction to consider his claim. And two, with regard to his allegations of coercion, the district court did not abuse its discretion in finding his assertions of coercion lacked credibility. Briefly into some of the facts, the government and Glover agree that the funds were turned over to the DEA out of a concern for the source of their funds. And that's on JA 35 and 40.
They were turned over, counsel, you said they were turned over due to a concern?
A concern for the source of their funds. That's the language.
Weren't those funds escrow funds?
Those were funds
Were they
from the
escrowed?
record.
Were they escrowed funds?
Your Honor, the record isn't clear on that.
Wouldn't they have to be? If counsel received funds from a client, he or she couldn't just put it in a personal, right? Wouldn't it have to be escrow account?
Yes, Your Honor. I would assume that they were escrow funds.
So the council gave you escrow funds and you took them and you knew that they were escrowed funds.
Yes, Your Honor.
Is that appropriate for the government to do that?
If there's nothing that prevents the government from going after funds paid to an attorney, if the attorney has reason to believe that those funds were illegal funds, a reasonable basis to believe that they were illegal.
You didn't go after them, though. You didn't. He turned them over. That's based on your investigation. You made no real findings of forfeiture or seizure, did you?
No, Your Honor. That's because they were voluntarily turned over, and then the DEA.
They can't be voluntarily turned over if they don't belong to the person they're turned over. They're escrowed funds.
Your Honor, it's no different than if somebody else finds money or is given money that is illegal and then turns that over, because under the forfeiture statutes in 881, the property interest in those funds vests in the government the moment the crime is committed. So those funds technically could not have been paid to the attorney in the first place.
But what you have now are funds turned over to their lawyer. You're talking about finding funds that are, you had no findings done as to whether or not this was elements or the product of any kind of, you just took funds that were escrowed from the client.
After we were informed by the attorney that they were drug proceeds.
Well, the attorney didn't know that. The attorney was concerned about the source of the money, but just because the lawyer, just a second, let me finish my question, if you wouldn't mind.
Yes, ma'am.
Just because you have a question about the source of the money as a lawyer, I mean, I had that happen to me when I was representing people. You don't go turn the money over to the police because you don't know. I mean, sure, sometimes you suspect that, but how does the lawyer have the right to turn over something that's not his to the police when he doesn't know? He may suspect.
Your Honor, on JA 35, Glover says that his attorney turned them over because they were drug proceeds. The government uses the language concern for the source, but Glover uses the language that his attorney told him they were turned over because they were drug proceeds.
Speaking in the dialogue, but I think that Mr. Weintraub, was that his name?
That's the Atlanta attorney, yes, Your Honor.
Was clearly concerned that, how did this man have this much money? What was the source of it? But how do you get to the point where he has a right to turn that over to the police?
Your Honor, as long as the attorney believes that they are drug proceeds, there's nothing that stops him from turning over. It may not be the approach that most attorneys would take, but it's the approach that this attorney took. The other problem
the money wasn't given to him in trust by the client?
No, Your Honor, it wasn't given to him by the client. Glover says the money was paid by family and friends, not by himself.
Right, exactly. On his behalf in trust?
Yes, Your Honor. The problem with Glover's claim, the main problem is that Glover never filed a timely claim with the DEA to contest the administrative forfeiture. If he had done so, it would have kicked the process over to the district court, and he could have had a hearing on whether the funds were tainted or untainted, or whether the attorney had or could have turned the funds over.
Okay, Mr. Gant, let me ask a question, and this is just a practical question rather than your ultimate legal arguments. I mean, Mr. Glover clearly wanted the money to hire a lawyer. He kept asking the judge, and the judge said, well, that's civil or that's whatever. And Mr. Glover, though, maintained his position consistently. I want a lawyer. I've got the money to hire a lawyer. And the judge kind of blew him off, didn't he?
He did, Your Honor, but that's because the judge didn't have subject matter jurisdiction, and he couldn't have that jurisdiction until Glover filed a claim.
Did he ever explain that to Mr. Glover, why he was just ignoring it?
There is a moment in one of the hearings where the court says, to my knowledge, there's a claim that you can file for that. And Glover acknowledges in his pro se pleadings that the DEA provided him with notice about forfeiture. And Glover himself says that he told his friends and family not to file a claim because they were going to be charged with money laundering. So the problem with all of his claims with the district court, even if you assume that filing that with the district court was enough to put the district court on notice that he wanted to contest it, none of those filings would amount to a claim to contest the forfeiture because he doesn't say that the funds were his. In order to contest administrative forfeiture, you have to file a sworn statement that the funds are yours and that you're intending to claim them. Then the process kicks to the district court. But if that claim is never filed, 18 U.S.C. 983 makes clear that the only motion you can file is a motion challenging the DEA's notice and whether that was sufficient. As long as he received sufficient notice that the DEA had his funds and was going to forfeit those funds if he didn't file a claim, then Glover received sufficient due process to challenge it. He just didn't choose that route.
Mr. Gant, you just raised a point I wanted to ask you about, which is the issue of whether they were his funds or not. Seems clear these funds were, given to the lawyer in Atlanta, on his behalf. But is it significant for a farmer-related claim that he doesn't claim they're his funds? Does that matter under the law?
That would matter under Farmer because Farmer itself was about judicial forfeiture after a person filed a claim for funds. You can't get subject matter jurisdiction to have a Farmer hearing in the first place if you never file a claim.
But aside from the not filing the claim from a procedural standpoint, I'm asking the question about whether Farmer you have to assert they're your funds as opposed to funds on your behalf. Can you help me on whether that matters under the law?
Your Honor, the way I read Farmer is it takes the same approach that the Supreme Court took in Lewis, where the only question is whether the funds are tainted or untainted. If they're untainted and the funds are necessary to retain counsel, then they can't be restrained. Then they can't be restrained. But if they're tainted, or if a person forfeits their right to those funds by not filing a claim with the DEA, then they never get to the Farmer hearing. And Your Honor, with regard to subject matter jurisdiction, this court made clear in Ibarra in 97 that once the administrative forfeiture process begins, the district court is divested of subject matter jurisdiction, and it remains without jurisdiction until a claim is filed. The Seventh Circuit has held the same thing in Mohammed in 06. There was a different case, though, where the AUSA misled the defendant into believing that filing a claim with the district court was sufficient to contest administrative forfeiture. That didn't happen in this case. The 11th Circuit held the same thing in Mesa Valderrama in 05, and that was a decision after CAFR was enacted, and it held the same thing, that because of 983E, a district court lacks subject matter jurisdiction to hear any claim regarding administrative forfeiture once it's complete. Glover doesn't challenge that notice. He doesn't say it was deficient. He doesn't say he didn't have sufficient time. Instead, he goes straight to say that the funds were tainted or were not tainted. Administrative forfeiture isn't designed to decide whether funds are tainted or untainted. It's only designed to decide whether a person will claim funds. Glover didn't do that. His family and friends didn't do that. And the record makes clear that he told people not to file a claim. And Your Honors, I'm happy to explain more about administrative forfeiture, but if the court has no other questions in that regard, I'll move on to the second claim about coercion. A couple of facts about his allegations of coercion that are pertinent to this case. First, Glover's case was associated with 4 different attorneys. The Atlanta attorney that we've discussed, who turned the money over to the DEA, a private attorney who made a limited appearance but wasn't retained, and 2 court-appointed attorneys. His first court-appointed attorney was removed a month into the case because the court wanted to accommodate Glover.
Counsel, can I interrupt you? I appreciate that background, but if you want to return to that, that's but we spent a good time reading that. So here's my question. First of all, do you concede that a motion to withdraw a guilty plea is an important enough part of the proceeding that the Sixth Amendment right to counsel attaches?
Yes, Your Honor.
Okay. So then how do you deal with the issue your colleague raised? I mean, I get we have facts here that, are unique based on some of the stuff you were, I think, going to talk about, the variety of counsels, the variety of issues. But yeah, how do we make sure that take it out of this case? Assume there, is a actual conflict, and the client raises it. How do we make sure that the defendant is not left on his or her own to deal with a motion to withdraw? How do we make sure that doesn't happen? In ruling on this case?
Your Honor, I would say there's a two-step approach that the court could take. The first addresses whether the court adequately inquired into the conflict, the alleged conflict. If the court adequately inquired, and I know you said assume that there was a conflict, but there's a two-step process that I think applies. If the court adequately inquired into the process and found that the allegations lacked merit or weren't credible, then you can stop there. If you find that the court didn't make an adequate investigation, and then you can go and look at the facts alleged and assume that they're true, and then decide whether there's a conflict. If there was a conflict and the court didn't adequately address it, then that's an error and it needs to be addressed.
So where is that, counsel? I mean, that issue kind of relates to what I asked your colleague, which is can the district court, in the face of allegations, look at the record and inquire into it and make a decision on that? And that sounds like that's part of your answer. Is there authority that you would point to on that issue?
Your Honor, I would point to a few things. First is this court's decision in Smith in 2011. The second is the Bachman decision, that's a 2000 opinion. And the third is it's a United States versus Craig, that's a 93 opinion. Bachman and Craig both dealt with allegations of coercion or an involuntary plea. And in both instances, the court did not appoint substitute counsel, but instead was able to credit the Rule 11 colloquy to say that the post-plea assertions were not credible, and therefore the court didn't have to appoint counsel. If all the court can do is look at the hearing and the allegations, and then it's handcuffed into almost always having to provide replacement counsel as long as the defendant files the right motion. If you take the motion that Glover filed and you tweak it a little bit to match your case, you're automatically entitled to a new attorney if the court isn't allowed to make credibility determinations. And this court is able to look at what the district court did and decide whether it adequately investigated. In this case, in the Craig opinion, that the court didn't even hear from the defendant. It only allowed counsel to address the issue, and then said the sworn Rule 11 statement contradicts what you said, and your allegations that you were coerced or didn't plea voluntarily lack merit and lack credibility. And this court affirmed.
But Mr.
This
Gann,
court wouldn't even.
Mr. Gann,
yes, Your Honor.
In this case, isn't that totally different? The conflict was voiced right on the record, where the counsel admitted, well, basically, in short, I know better than he does. I want him to do this. It was clear they were in conflict. Isn't that on the
Your Honor,
isn't that on the face of the record they were in conflict?
Your Honor, it's clear that Glover created a conflict. It's not clear that a conflict did exist.
He created one by not agreeing with his counsel. Is that your position?
A conflict did arise whenever he accused his counsel of coercing him into pleading guilty, but that does not mean that he actually coerced him into pleading guilty.
But didn't his counsel say on the record that I want him to do this?
The counsel said it's in his best interest, Your Honor. And then I believe he stopped from going further.
Wait a minute, counsel. Wait a minute. Wait, let's use some common sense and look at the thing. Isn't it clear he was saying that I think it's in his best interest, but my client doesn't?
Your Honor, that could have been because he got a stipulated sentence to the mandatory minimum of 120 months. And without that...
Wait a minute. The lawyer doesn't do, no matter how great the deal is, the lawyer can't decide that unilaterally.
That's correct. He can't decide that the plea agreement should be that he has to plead guilty.
And you tell the judge that basically right in front of the judge, I think this is the best for him, and he really doesn't know. Why is that not a conflict?
Your Honor, I think if you take it a step further, let's say that the court did appoint substitute counsel, and then if that substitute counsel investigated the claims and found that they weren't supported by anything, that counsel would be in the position of not arguing Glover's argument as well, and that would be against Glover. So it's possible that that Glover's argument simply lacked merit at all.
It's possible that it lacked merit.
Yes, Your Honor, and the district court adequately inquired into the situation to find that Glover's allegations.
That turns the Sixth Amendment on top of his head. How can it not be important and intrinsic to the client to determine whether or not they're going to give up all of these rights?
Your Honor, maybe
wait a minute. No matter how good the deal is, what do you mean? He created the conflict. There was no merit to the conflict. There's always merit if I don't want to plead guilty.
I agree, Your Honor. I'm not saying that the attorney gets to decide that the plea should not be revoked, or that it is certainly up to the defendant to decide whether to plead. But it could also be that a defendant filed a motion simply because they didn't want to go to prison and they wanted to create a conflict and delay the inevitable. And that's what the court thought that Glover was doing. It looked at his prior conduct and filing, I think it was 40-something motions before the court, despite the fact that he was represented. It looked at the fact that he had tried to remove both of his court-appointed attorneys, one of them right before the plea where he made accusations that clearly lacked merit and that were then refuted by the prison logs. And then the fact that his sworn Rule 11 statement stated explicitly that he was not coerced, that it was his decision to plead guilty because he was in fact guilty. Glover does not claim that he is innocent, and he does not contest anything other than the fact that he filed this motion saying that he was coerced. And the only question is whether the court adequately inquired. If it inquired, and this court believes that that was adequate, the court isn't handcuffed into providing substitute counsel. Now,
okay,
Glover
but Mr. Gant, if we find that the record is insufficient to show that the court adequately inquired, then you have a problem, don't you?
Your Honor, in that case, this court has two options. One, to remand for the limited purpose of the court to hold a hearing to inquire further or appoint substitute counsel and argue the coercion claim. Or two, deny it and say that it isn't appropriate on appeal and that it should be brought in a 2255, and then Glover can then have an evidentiary hearing. Your Honor, I think in this case, the court's approach was to look at the case as a whole, and the district court is in the best position to observe the relationship between the counsel and his attorney, the counsel and his client, and that it was not an abuse of discretion for the court to say, based on your prior conduct and based on these allegations, I think they lack merit. Even if you get to if you find that the court abused its discretion, you can then look to see whether the claims themselves would arise to a coercion to make the plea involuntary. And in that case, I think this case is significantly different than the two First Circuit cases that Glover relies on. In Sanchez-Barreto, there were several allegations of coercion. The only one that the court remanded on was the one where the attorney walked into the hearing and attempted to withdraw, and that was a red flag that the court should have caught and should have then appointed substitute counsel and not made the attorney continue. The second one is Seguier-Rivera. That's an 2007 opinion. That one, the client didn't speak English. He had a limited education. He was confronted with his wife in prison to convince him to plead guilty. He responded on cue. There was allegations that the attorney concealed evidence. Those allegations go significantly far more in depth than what Glover has alleged in this case.
Mr. Gant, wasn't there a motion scheduled the day after the plea?
Your Honor, I'm not exactly sure whether there was, but Glover does say that there was.
You don't know the record?
I do know the record, and I know that there were hearings coming up after the plea. I don't know exactly how far away they were.
Weren't these hearings to decide whether or not he was still trying to get the funds back?
The government, I'm sorry, Your Honor, I see I'm out of time. Can I answer?
Yeah, you may.
There was a potential farmer hearing at issue, but the court had not decided what it was going to do with that.
But it was pending the next day after the guilty plea.
That's correct, Your Honor, but the court lacks subject matter jurisdiction.
How could you have a legitimate Rule 11 proceeding for a guilty plea and you know the next day is scheduled to decide whether or not he can get the funds and get the lawyer that he wants? So if you ask questions like, well, are you pleased with your lawyer? Well, Your Honor, if you look on the docket, next day I got trying to get another lawyer. So the answer is, how could it be an answer that yes, even on this record. The next
Your Honor,
day, wait a minute, and you say you don't know the record, but it was the next day, wasn't it?
I believe that's correct, sir.
Yeah, that's why I asked you the first time. And it was the next day, you got a motion to decide whether or not I can get the money to have the lawyer that I need and want. But then that day you're pleading and your lawyer said, no, I think this is best for him. How do you have a Rule 11 colloquy and say, I think they ask questions like, are you pleased with your lawyer, correct?
Your Honor,
are you satisfied with the work your lawyer's done, am I right?
Yes, Your Honor, that was the question, and he said yes, and it's very possible that Glover changed his mind and decided to take a sentence at the mandatory minimum.
It's very possible.
And that is
very possible.
Yes, Your Honor, and that's what he stated under oath, that he was pleading guilty because it was his voluntary decision.
Oh, okay, all right. Thank you.
Thank you.
Mr. Milling?
Thank you, Your Honor. And if I may just start off by responding to Mr. Gant's supposition that it's very possible that he changed his mind. And I would submit respectfully that it's very possible, and in fact, more likely, that my client saw the record for what it was, that he was not getting a hearing. He was not getting a new lawyer. He was given the opportunity to proceed pro se, or he was given the opportunity to proceed with Mr. Ailes, a lawyer against whom he had already tried to relieve his counsel, and Judge Kane had said, you are not getting another court-appointed lawyer. If we look at the record as a whole, going back to before he even arrived in district court, he was trying to hire a lawyer of his choosing. He was never given that opportunity. So Judge Gregory, to your point, he knew that he wasn't going to get what he wanted. He was simply trying to make the best out of the situation because he was given two bad choices at the time of the guilty plea. You're absolutely right. He had a hearing scheduled the next day, and frankly, he was given the choice. You either plead guilty or you go into trial, and you may or may not have to go to trial with Mr. Ailes, a lawyer against whom you've already tried to get relieved as counsel. We fast forward to the motion to withdraw the guilty plea, and unfortunately for Mr. Glover, the court starts off the proceeding on page 289 of the JA asking whether or not he's competent. If that doesn't telegraph to Mr. Glover where Judge Kane's mind is, I don't know what does. And then he goes forward to say, Glover is trying to set up an appeal or a 2255. There was no inquiry into the record as to the sum and substance of these allegations. And it is above and beyond.
Mr. Milling, let me stop you there. I mean, you say there's no inquiry into the record. I understood your earlier position that really you don't have to have an inquiry, that if the allegations are such, you automatically get a new counsel. But I mean, I can give you the cites. I mean, we could debate whether it's an adequate inquiry, but he asked Mr. Glover about his claim. Mr. Glover responded. He asked the assistant U.S. attorney. He asked the lawyer. And then he discusses the evidence or the responses he gets from everyone on the record. I mean, I grant you it was in the context of the Moore hearing and not discrete in the other issue. But, I mean, you know, it seems like he does address the substance of it actually relatively thoroughly. I mean, you know, so to me, this seems like the question is, does the district court have the right to go into that, or do the mere allegations trigger the right to a new counsel? You know, you say the latter, your colleague says the former. Seems to me that is at least one important issue here.
I would agree, Your Honor, that that's a very important issue, and I stand by my position that once these allegations of a conflict arise, then he needs a lawyer to be able to represent him moving forward, like we would see in a 2255 hearing. But because Mr. Gant raised the issue of looking at the record, I wanted to make a quick point of being able to talk about some of the things in the record. Because when the district court turns to Mr. Ailes, that's when he says, I didn't endorse, nor did I file this. To Judge Gregory's point, the lawyer doesn't have the opportunity to make a choice of something as fundamental as this. It's the client's. The client is the only one who can choose to plead guilty or not. Likewise, is the client's decision.
So
Yes,
that's an interesting question. So I mean, if the lawyer thinks, given the record, the evidence against the defendant, that filing a motion to withdraw is not in his best interest, are you saying he must go forward and argue for that?
I believe
Or
so,
he can?
Your Honor. I believe
Okay.
so. And I've had to do it representing clients in the district court where I have negotiated pleas on behalf of the client, where the client has chosen to accept those pleas. And thereafter, the client comes forward and says, I want to move to withdraw my plea. And so what I, as counsel, did was go through and walk through the different more factors and address them as best I could on behalf of my client, while trying to make sure that I was providing as zealous an advocacy for my client as I could. It's not always easy, and I'll be the first to admit that, but that's not my decision whether or not to make that motion to move to withdraw the plea. Now, part of what lawyers are supposed to do is make sure that you've got a good enough relationship with your client, that you can talk to them, that you can counsel them, that you can provide that guiding hand that our Supreme Court talks about, and make sure that they understand what some of the potential consequences are, what the elements are, and inquire of the client, what do you submit we need to argue as it relates to representation of innocence, for example. Yes, sir. But,
I'm just go ahead. I'm sorry. I think I understand your answer. I appreciate that.
And that's where the district court, knowing what it had to look at, if we even got to the more factors on a motion to withdraw, should have asked questions of Mr. Glover, and Mr. Glover should have had a lawyer to be able to advocate on his behalf for some of these points under Moore, as to whether or not he was asserting his legal innocence, as to whether or not the plea was knowing and voluntary. And as has been presented here before, looking at the record, it is clear that there was a conflict, that there was a problem, that there were challenges and difficulties between counsel and Mr. Glover. And while the district court surmises that was something that was created by Mr. Glover, it is the job of counsel to make sure that you are advocating on behalf of the client. There was no advocacy whatsoever at the critical stage of the motion to withdraw the plea. And that's where my client was denied his right to counsel. He did not.
And Mr. Milling?
Yes, ma'am.
Ms. Milling, what is determinative then? Is it the fact that the court didn't conduct an adequate inquiry, or the fact that counsel didn't advocate, or both? In other words, is one of those sufficient to require reversal in your view, or do we have to have both? I
think it's either. I don't think we have to have both, because there are responsibilities on both counsel and the district court. The district court has a responsibility to preserve the record, to make sure certain things are done. And frankly, what the district court should have done is hired counsel to be able to advocate, because the judge is supposed to be neutral. The judge is supposed to protect the record and make sure that the rights were preserved here, and that wasn't done. Even if there was a lawyer who was appointed to represent Mr. Glover at this hearing, if they had not advocated, let's say it's Mr. Ailey's best friend and he doesn't advocate on behalf, or he's appointed in the courtroom and he's not able to provide full presentation on the issue, the Sixth Amendment is violated there as well. And so I think that Judge Keenan, in either scenario, we can give rise to a vacation of the judgment and a remand. And I see that I'm out of time.
Thank you, Mr. Milling.
Thank you, Honors.
And thank you, Mr. Gant. Mr. Milling, I note that you are court appointed. And
yes, sir.
I just want to say on behalf of the Fourth Circuit, we thank you so much. Counsel like yourself take these cases to help us, and we really appreciate it. And Mr. Gant, we acknowledge your able representation of the United States. We wish we could come down and shake hands as our normal tradition, but we cannot. But know nonetheless that we appreciate your being here and your fine arguments. Be safe and stay well. Thank you.
Thank you, Honors.
You may proceed whenever you're ready.
Thank you, and may it please the court. This case is about a simple injustice. It should not be possible for an individual to lose her taxpayer-funded job due to an easily accommodated physical disability. If the Americans with Disabilities Act and the Rehabilitation Act stand for anything, it's for equal opportunity of the exact sort Ms. Smith was denied. But first, I need to address issues of misclassification and joint employee status, so I'll start there. From 2013 to 2017, Ms. Smith worked on a DEA contract in Springfield, Virginia. The contract was administered by a couple of different companies over the years, but CSRA administered the contract at all times relevant to this complaint. During that period, Ms. Smith had control over her own work and her own work schedule, so long as she provided the deliverables her contract required. In April 2017, Mark Schaffernick, the DEA's chief technology officer, told Ms. Smith that her worksite was going to change to DEA headquarters. But at DEA headquarters, everything about Ms. Smith's work changed. This was a complete break from the way she had been treated at Springfield. When she reported to DEA headquarters, suddenly Ms. Smith was told when to work, how she must do her work, how many hours per day she was allowed to work. She was treated exactly like the DEA and CSRA employees around her. And her program manager, Scott Barnhart, made that clear at his deposition. He noted that the only difference between contractors and employees were compensation and benefits, which are certainly factors here, but by themselves are not sufficient to determine independent contractor classification. This court laid out a test for joint employment in Butler v. Drive, the automotive industries.
Okay, but Mr. Ehrlich, it seems to me that perhaps you may be deviating from the main point that we've got to consider. She said she was an independent contractor. Everything that she signed was that she was an independent contractor. So really isn't the proper focus here what remedies she had as an independent contractor? Does the Rehabilitation Act cover independent contractors? Isn't that really where we need to look?
I don't believe so, Your Honor, for a couple of reasons. One, the Garrett test looks to 11 factors, the 11th of which is
but what about the fact she said that she was an independent contractor? Please address that before you go.
Absolutely, and I'm not going to go through all 11 Garrett factors, but the 11th one is the intention of the parties. And it is not among the factors that it is most important in the analysis. And we don't contend that Ms. Smith was anything but an independent contractor until she moved from the DEA worksite in Springfield to the DEA worksite at headquarters in Arlington, at which point the terms of her employment completely changed. When she moved there, as I mentioned, Scott Barnhart said, her program manager, that CSRA employees and contractors were given the exact same treatment. So, and as the court mentioned or laid out in Butler, there's a test for finding joint employment status. And the district court erred in the way that it applied that test, because what it did was compare CSRA and the DEA's roles in Ms. Smith's employment, rather than considering the factors together to determine if collectively the two entities amounted to joint employers. So,
Mr. Ehrlich, can I interrupt you and just make sure I understand the framework of this, issue? I appreciate that being an issue for the claims as it relates to CSRA. Isn't it true that neither party below addressed that issue as it relates to DEA? And is that correct?
Neither party addressed it below, but only because the DEA chose to concede that for the sake of argument, and focus only on the merits. And it's impossible for the court to have considered joint employment with DEA and CSRA had had the issue not been addressed with CSRA. So my position is, by addressing joint employment with CSRA, you can't do that in a vacuum. You have to look at both employers, which is one of the concerns we have about the district court opinion.
Does am I right that your only claim against DEA is with respect to the Rehabilitation Act?
Yes, that's right. The ADA would not apply.
Okay, and why doesn't the ADA
court
apply? Excuse me, Mr. Ehrlich, why doesn't the ADA apply? Sure. It doesn't apply because she's an independent contractor, isn't that correct?
It doesn't apply because.
So if it doesn't apply because she's an independent contractor, you see what I'm saying? Where I'm going?
I do understand what you're saying. Title I of the ADA would not apply because they were a government employer, not because she was an independent contractor. Although I concede it does not apply to independent contractors, but our position is that she was correctly classified as an employee, which is not foreign to the cases in this circuit. In Crump v. Department of Navy, the Eastern District of Virginia found a contractor who had been at the Department of the Navy for just 1 year was considered a joint employee with the Department of the Navy, even though there was no formal employment relationship. The district court, an example of what I was saying about the district court, is that it found that although CSRA had the contractual authority to terminate Ms. Smith's contract, it was the DEA that directly caused the termination of plaintiff's contract. And we contend that the contrast drawn there is exactly backwards. The issue is that taken together, CSRA and DEA had such authority, because Butler states that the joint employment doctrine captures instances in which multiple entities control an employee, and that the reason the test exists is to, quote, pierce the formalities of an employment relationship to determine the locus of effective control.
Okay, Mr. Ehrlich, excuse me. How could Smith be an employee of the DEA when she wasn't even an employee of CISRA? In her contract with CISRA, she disclaimed any employment relationship and said she was an independent contractor. So how do you get the leap to her being an employee of the agency hiring the prime contractor? Seems to me you're trying to punch a square peg into a round hole.
Absolutely, Your Honor. The way that we get there is, first of all, that this court has made that leap at least twice in the past, and we believe several more times. In Luna Reyes v. RFI Construction, LLC, and Salinas v. Commercial Interiors, Inc., this court found that an independent contractor was not only an employee of the entity that contracted that person, but in fact a joint employee of the prime contractor above. So this court has made that leap. To the best of our research, this court has not made that leap in a discrimination case, but is
it in the context of statutory employment?
It is in the context of statutory employment.
Okay, that's an entirely different construct, isn't it?
I'm sorry, Your Honor. I misspoke. I apologize. It's in the context of employment as evaluated under the Garrett and Butler test. I apologize for that. As I was mentioning, the Salinas and Luna Reyes, and there's also a case involving AT&T, were all Fair Labor Standards Act cases, but the analysis done was the same analysis. And there's really no reason that this court can't use that analysis in the discrimination case. If there aren't any other questions about independent contractor issues, I'll move on to the accommodations issues. There's no disagreement that Ms. Smith had a disability, and there's no doubt that if the ADA and Rehab Act apply in this case, she is a qualified individual with a disability. When in April 2017, Mark Schaffernick told Ms. Smith that her worksite would change to the DEA headquarters, Ms. Smith took immediate steps to secure the accommodation she needed. On April 28, 2017, prior to changing work sites, Ms. Smith reached out to her program manager to secure the same accommodations that she had had for years at her new work site. Once Ms. Smith moved to DEA headquarters without the accommodation she needed, there was a preliminary discussion of a part-time work schedule as a potential accommodation. When the district court evaluated that issue, it erred in finding that the part-time schedule could be a reasonable accommodation in this instance, and that such a schedule was even formally offered to Ms. Smith. The part-time schedule would not address the core concern that Ms. Smith needed to be accommodated, which is that a walk from DEA the DEA parking available for contractors to DEA headquarters caused her excruciating pain. Asking her to do that 3 times a week instead of 5 times a week did not address the actual underlying issue. It is the same thing as if Ms. Smith used a wheelchair and she was told that she had to access a building that did not have a wheelchair ramp. They were simply asking her to do something impossible. So it was not a reasonable accommodation to ask her to do something that she could not do. Regarding the issue of whether that was ever actually offered to her, there was a preliminary discussion on May 10th, and Ms. Smith did respond negatively to that. But we know that CSRA and DEA didn't take that as a rejection of the offer because they continued to work on it. On May 19th, 2017, the DEA finalized a formal offer of an accommodation to Ms. Smith, but they never sent it to her. There is no document showing that Ms. Smith ever actually saw that offer. And while it's true that appellees need not provide the exact accommodation for Ms. Smith that she sought, they were required to provide a reasonable accommodation.
So Mr. Ehrlich, I mean, I think I understand your argument about the part-time. I mean, I can appreciate, you make less. The definition of accommodation includes part-time. So don't you have to consider the part-time? I mean, I know your client wishes and complains that it wasn't done sooner, but don't those things work together? They offered a temporary option that would have required, granted, it doesn't fully solve the problem, but it requires less of that physical burden while they're looking at the parking pass, which they ultimately granted. Help me.
Absolutely. So there are reasonable low-cost accommodations that appellees could have offered that would address the concern in a stopgap way until the parking pass was granted. For example, the circuits recognized leave without pay as a reasonable accommodation. And while Ms. Smith wouldn't have been particularly happy about leave without, it was simply impossible for her to accept. So it does not amount to a reasonable accommodation by any definition.
Correct me if I'm wrong, but I didn't see any evidence in the record that she had medical statement that she had to telework. There's nothing in the record.
There were.
There's medical information. We need to focus on the parking pass and why that wasn't a reasonable accommodation.
So there are a couple of notes from doctors on May 4th and May 9th. I believe the May 4th note exclusively on the parking pass, because had she received the parking pass, she would have done what the company and what the appellees want. What I'm saying is that although I don't think 5 weeks is an unreasonable amount of time to provide her with the parking pass, that in that interim, they created a situation where they asked her to do the impossible and then turn with the ADA or the rehabilitation.
What about the evidence that they terminated her because she insisted on continuing to report to Mr. Schaffernick and not to Mr. Tyler and Mr. Ten, as she had been required once they moved to DEA headquarters. And also there was an issue, I think, on her having some personal information on her computer. I guess that wasn't ever proved. And there doesn't seem to be any material dispute in the record. She was still reporting to Schaffernick, even though they told her she had.
Schaffernick. Her contract specifically says that she reports to Mr. Schaffernick and that her deliverables go to Mr. Schaffernick. And one of the reasons that supports her change from an independent contractor to an employee status is because appellees started violating the contract, at which point she was an individual who went to work and did labor inconsistent with her contract in a way that can really only be described as employment. And with respect to the information security issues, those are disputed issues of material fact. Without getting into the weeds of it, functionally what happened was Ms. Smith was set up with two different accounts to DEA laptop or personal laptop. What it was that the account that she used to access DEA information for years was set up at her personal laptop or at her work laptop, a totally new account. She didn't have access to any of her prior work, and without access to her prior work, she couldn't keep doing her job. Those are all things that we feel we can very comfortably contend at trial.
You know, the record's kind of unclear as to exactly what sort of work she was doing. Said she was a geospatial analyst, computer-oriented. Is that right?
That's right. Her job was...
Like, what was her educational background? What kind of work was she actually doing?
So she was hired according to her contract as a subject matter expert in these geospatial intelligence issues that are used for law enforcement. She had access to non-classified but sensitive government information, and my understanding of her work, which I'm certainly not expert in, is that she essentially used geospatial information to support law enforcement efforts at the DEA, but also across agencies.
So she was a computer expert. Is that what you're saying? Or
she was. Her work was all computer oriented. She is a geospatial intelligence expert.
And so how's somebody trained for that? I don't want to belabor it, but just helps us to understand.
Your Honor, I can't say that when I get back. But one last thing, and then I'm way over, so I will stop after that.
Counsel, are you asking for extra time?
No, I'm not. I'll stop here. I think I've addressed everything I need to address.
If you want to just conclude, but you have time reserved, but let's just say this. It's just a quick question. Everything that she needed for her job was on the computer, correct?
That's absolutely correct.
And I understand you can't talk about what she did because it's a sensitive thing, but to complete her job, she could sit in front of that computer, whether she was 1,000 miles away or in the office. Isn't that right?
Not only is that completely correct, but Mark Schaffernick had 4 similar employees moved to DEA headquarters, and of those 4, only Ms. Smith's remote work token was withdrawn.
Right.
And the only other thing I was going to mention is that among the ways that appellees stop abiding by Ms. Smith's contract is that Ms. Smith was told by Kevin Sang, her new supervisor, that she was no longer to act as a subject matter expert. So at that point, she wasn't a subject matter expert. She wasn't reporting to the person who her contract said she had to report to. She was being treated as an at-will employee who has to do what the boss says, which is a perfectly fine thing to be, but it's not a subcontract.
Right,
that's
go ahead. What did you say?
Oh no, I was just going to say thank you for your time.
Oh, okay.
But
thank you, Mr. Ehrlich. Ms. Levinson?
Thank you, Your Honors, and may it please the court. Plaintiff Tina Smith, a former DEA subcontractor of DEA's geospatial mapping program, brought 2 Rehabilitation Act claims in this case, one for failure to accommodate and one for retaliatory termination of her services with DEA. And I will address each one of these in turn. As to plaintiff's failure to accommodate claim, plaintiff failed to contest at summary judgment, and the record evidence is unrebutted that DEA offered plaintiff 2 accommodations, including one accommodation that she expressly requested during the short period that she worked at DEA headquarters. Specifically, within days of starting at DEA headquarters, DEA offered plaintiff part-time work on site, which she rejected. And as plaintiff has conceded in this opening argument, 3 weeks later, DEA offered plaintiff her preferred accommodation of a parking pass. Plaintiff's only argument regarding the part-time
Wait a
work.
minute, counsel, you said how many weeks after did you give a parking space?
3 weeks after the part-time offer, Your Honor.
So you went from the first request, you go to part-time,
Yes.
not a parking space. Well, you know, we recently had a case to talk about in terms of what arsenal is available for accommodations. And this is sort of reverse engineering. There was a question of whether or not the person, wanted a question that can I bump someone else, in terms of seniority. And we laid out an opinion and said, well, that might be something in the arsenal, but you don't get to that first. So you start with part-time. I mean, pardon me, but most people can't afford just to have a, 2/5 reduction in their pay and a reasonable accommodation. You start there, and then 3 weeks later you have, we can't give you the parking space. Is that, you believe that that's a good faith fulfillment of accommodation when you start off saying, we'll accommodate you, take 2/5 less of your pay?
Your Honor,
that's consistent with the law?
Pardon me. Your Honor, the ADA is quite clear that part-time accommodation is reasonable, and that's at 42 USC.
It's reasonable in some circumstances, but it's not. So you can't, that would be, if that's reasonable per se, you would say every request could be, all right, well, we'll reduce your burden by 2/5. You said.
Certainly not.
So you're saying that complies with the law just because that is something in the arsenal?
Your Honor, pardon.
It's a continuum, isn't it? You start there?
I would certainly note that it's a fact-based inquiry. Plaintiff, however, in his opening argument, offered the idea of leave without pay as a first reasonable accommodation, and this part-time offer would certainly pay plaintiff, who the record shows was making about $360,000 a year. It would certainly give her more income than leave without pay. I would also note that plaintiff was asking for to appear at DEA 50% of the time, and that was an accommodation that DEA could offer immediately to try and meet that request. And it's also worth noting, contrary to plaintiff's argument in the opening, the plaintiff's work was not exclusively confined to a computer. In fact, she was a liaison self-described between multiple parts of the government and DEA on the geospatial mapping program. Indeed, on her first communications with DEA, for example, on page DEA headquarters on page JA 842, expressed that she'll be moving to different, going to DOJ JMD one of her first days there, and would be at a 5-day conference at the National Geospatial Intelligence Agency on one of the weeks when she was supposed to start at DEA headquarters. So contrary to plaintiff's own arguments, the part-time offer was an effort to allow plaintiff to come into the office, but to do so in a way that would try and meet her needs. And it is also worth noting, for example, in this court's precedent in Hannah P. versus Coates, that DEA observed that the program on which plaintiff was working was not doing well, and that is the whole reason why her services were moved under new management at DEA HQ. DEA was entitled to determine that to the extent her remote work could be considered an accommodation prior, that when that work was not being performed well, it could try and take new steps to find a new accommodation. Oh, yes.
So, counsel, on that point, the issue of whether they had concerns about the way the plaintiff was, operating, concerns about being remote. I think from my review of the record, those are articulated in the record. What I didn't see really articulated is any sort of like official, here are the problems we've identified with what you're doing, you need to correct them. And so my question is that required, or is it not required because this is an at-will employee and the real question is, why did you terminate them?
Yes, Your Honor, I agree with your second premise. Tina Smith was an at-will subcontractor of DEA, and a high-level DEA employee made the determination that the program that she was working on and for which she has put her name was not serving DEA's interests. It is certainly apparent from the record that the decision to move an entire program under new management constitutes a view that this needs to change. That certainly isn't something that's done arbitrarily. And then, as the record does reflect, there are efforts by DEHQ members to try and get control over the resources that are coming, Tina and a co-contractor who are coming over to HQ. So while there isn't any explanation of the reason for the move at that moment, there's certainly unrebutted testimony in the record as to why Quinn made the decision to move those resources over, and then unrebutted documentary evidence over the course of May 2017 and into early June, showing how difficult it was to work with these contractors.
So let me follow up with that just a little bit, because one of the concerns I had about the case, and you've addressed one of them, was quite frankly the district court's order, and as it relates, more than anything else, really to a couple things. It said that there were claims against the DEA for ADA and Rehab Act, which things happen. We always make mistakes. I think it's just the Rehab Act. But then on the retaliation claim under that act, the district court found that the ultimate supervisor, Ms. Quinn, had no knowledge of the EEO complaint. And that seems to be wrong based on the record. There is a timing area there that we often look at. I mean, the termination was soon after the knowledge. And so, one could look at that and say, maybe there's a question of fact there. But I'd ask you to consider whether the causation standard under the Rehab Act is relevant to that inquiry, which, as I understand it, is a solely causation standard. So if you could, on the one hand, I'm worried about the question of fact potentially based on timing, but I'm wondering whether the solely under the Rehab Act addresses that. Could you help me with that? Judge Keenan may have a follow-up with that, so I'm glad to.
Yes, thank you. I apologize, Judge Quattlebaum. Didn't mean to cut you off there. If you could piggyback onto Judge Quattlebaum's answer, the chain of command issue, and whether that was just, and how that plays into, as Judge Quattlebaum said, the Rehab Act requiring solely, in distinct contrast to the ADA requirements.
Certainly, Your Honor. Broadly, the district court while there may be questions with respect to knowledge and with respect to the district court's holding on the prima facie case under the McDonnell-Douglas standard, and we address that in our brief, the district court's alternative holding with respect to the fact that plaintiff had not overcome Quinn's legitimate non-retaliatory reason for just terminating plaintiff services still stands despite the issue with Quinn's affidavit. First, mere knowledge, even assuming that Quinn knew of plaintiff's prior activity, is not sufficient to establish pretext. Moreover, this court's own precedents, for example, in the Price case that we cited, require some kind of evidence of mendacity, not simply a mistake, to look into pretext or to find pretext in the event of a mistake. And we cite some other examples of such cases in our brief. And there is no evidence in the record that there was some kind of purposeful misstatement by Quinn on the question of her knowledge. And third, and perhaps most importantly, plaintiff's burden on summary judgment was to rebut the legitimate non-retaliatory reason for Quinn's termination of her services. And the question of Quinn's knowledge does nothing in that respect. It certainly does not undermine the reason, which is supported by many record citations, which are found at 36, 37, 41, and 42 of our brief. And plaintiff's own testimony at her deposition and her production of DEA documents from her personal possession in this very litigation. Plaintiff has pointed to no evidence beyond the EEO affidavit, which again is insufficient on its own, to give the court any reason to doubt the legitimate non-retaliatory reason for her dismissal. And Judge Keenan, with respect to the question of the chain of command, plaintiff's contract says that her deliverables as an independent contractor, and I think that certainly means her work product, is deliverable to the CTO, which was Mr. Schaffernick. But it doesn't say anything about her requirement to provide information that's requested by other DEA employees. And there's evidence in the record of Ms. Tyler, particularly complaining, even before plaintiff filed an EEO complaint, that she was not getting responses to the questions she was asking, and that those responses were going mainly to Schaffernick. I think it's beyond dispute that a subcontractor, an employee, whoever you are, if you're working in a group, you're required to work well in that agency.
Okay, but what are you saying she was? I mean, are you saying she was an employee?
Your Honor, I think as the word is generally understood, we are saying that she is a subcontractor. For the purposes of the joint employer analysis, and therefore whether or not DEA could be held liable under the Rehabilitation Act, we acknowledge that that was a closer question and therefore did not move on summary judgment for that reason. And unless the court has any further questions.
I think you made it clear. You can't have it both ways. You just said that her contract said that her deliverables were to one person, yet you say when you work at a team, you expect people to respond to everybody all around. That's what employees do. You're right. But you just said, but then she's fired because these other people who are not in her contract are saying, well, you're not coming to me, you're not doing what I want done. Is that what you're saying? But you just said, it said deliverables, right? And that's who you deliver to, correct? So,
Your Honor, she was not fired because she did not deliver documents or deliverables to the CTO. She was fired because she was completely unwilling to work with other members of the DEA team in assessing a program that had been put under her management. And as the final denouement of that building tension, which is well documented in the record, plaintiff Quinn understood that plaintiff had been taking DEA documents on her personal computer. Whether that belief was mistaken, as this court's precedent holds, is not the question. It's just whether Quinn believed it to be true. But the fact that plaintiff herself produced DEA documents in this action should only further lend support to the legitimacy of Quinn's reasoning. And for those reasons and the reasons stated in our brief, we respectfully request that this court affirm the district court's judgment.
All right, thank you.
Thank
Mr. Ehrlich, you have some time reserved. I'm sorry, Mr. Ward. I'm sorry, Mr. Ward. I'm sorry, my fault. Mr.
No
Ward.
problem, Your Honor. Good morning. May it please the court. My name is Joseph Ward, and I'm here on behalf of Appellee CSRA, Inc. Plaintiff Appellant Smith has appealed only one issue as it pertains to CSRA, and that is whether the district court properly held that CSRA was not a joint employer with the DEA. This court should affirm the district court's holding on this issue because the record is clear that CSRA lacks sufficient control over Smith under the factors set forth by this court in the Butler versus Drive Auto case. I think a starting point is to reiterate that the district court correctly held that Smith was an independent contractor of CSRA and not an employee, an issue that Smith has not appealed and conceded in her brief and opening statement today. Consequently, to pursue claims against CSRA under the Americans with Disabilities Act, she must prove that, one, she was an employee of the DEA, which, as has been discussed today, was not an issue addressed in the lower court. And more importantly, that CSRA was her joint employer with the DEA. As to whether CSRA was a joint employer, the district court's decision properly examined the relationship between and among the DEA and CSRA insofar as the control exerted over Ms. Smith. In other words, the district court correctly analyzed the degree of control vis-a-vis both entities. And the court found that the three most important factors weighed in favor against finding a joint employer relationship. The first factor was that CSRA had minimal control over Smith as her work was for DEA. At DEA, she reported to a DEA supervisor, and CSRA exercised no workplace supervision over her. The district court aptly characterized this relationship as CSRA's role was simply to provide an expert in the field relevant to the DEA. CSRA did that by finding Smith and instructing her to report to DEA subject to DEA requirements. In her brief, Smith argued similarly that at all times, from the start of her employment at DEA, that her work was completed at the direction of and under the supervision of DEA. Therefore, it's our position that the first Butler factor weighs against a finding of joint employment. Second, although CSRA had the contractual authority to terminate the contract with Smith Global LLC, it was the DEA that directly caused the termination of the contract after Smith became incapable of fulfilling her contractual obligations to the DEA by virtue of the revocation of her security clearance by the DEA. This court in the Green versus Harris matter distinguished the Butler case and noted that unlike in Butler, which was a staff and agency client relationship, in the Green case, there was no concern about the putative employer's ability to terminate an employee as if it was one of his own, but rather its ability to ensure that the deliverables per the prime contract were met to the client's satisfaction. Similarly here, CSRA learned that Ms. Smith's project and therefore terminated its contract as that was the basis for that contract. And then the third factor the court determined weighed in favor, third most important factor the court determined weighed in favor against joint employer finding is that CSRA furnished neither the workplace nor the equipment. In analyzing these three most important factors, contrary to Smith's position in her brief, the court necessarily premised the comparison on the control exerted by the DEA and by CSRA. So plaintiff's contention that the district court's analysis is flawed in some way is wholly without merit. As far as discipline is concerned, the court noted that while in theory CSRA could mete out employee discipline, here that was not the case. She was not an employee, and even when CSRA attempted to kind of confine her to the requirements of the DEA, she disregarded CSRA's encouragement. It's our position that merely encouraging an employee to adhere to the client's specifications hardly amounts to exerting sufficient control to qualify it as a joint employer. The remaining Butler factors, with the exception of CSRA's administration of Smith Global LLC's payments, weighed against a joint employer relationship. This holding was in accord with Ratledge, which was decided by the Eastern District and affirmed by this court per curiam, as well as generally the Butler case, although as I mentioned earlier, the Butler case is distinguishable. Thus, it is our position that the district court correctly held that CSRA was not a joint employer of Smith, and we ask that this court affirm for the reasons stated today, as well as more fully briefed by our joint brief.
Thank you, Mr. Ward. Mr. Ehrlich, you have time reserved.
Thank you, Judge Gregory. Several things. I want to quickly address the timeline of Ms. Smith's termination. On June 4th, 2017, CSRA determined that they were going to terminate Ms. Smith. On June 5th, 2017, the DEA EEO office provided Ms. Smith with a parking pass. Importantly, appellees outside of their EEO office took no role in getting Ms. Smith that accommodation. She went to the DEA EEO office herself, going around normal chain of command because she desperately needed this accommodation. And the DEA EEO office, to everyone's surprise, granted her the accommodation. Appellees, the DEA office that she worked with and CSRA played no role in actually getting her that accommodation, which they had told her for more than a month was impossible for her to get. On June 7th, just 2 days later, Scott Barnhart sent an email acknowledging the accommodation and saying that they were going to put her termination on hold, but then laying out a plan to then terminate her. Barnhart said, I want to get this quote correct. Barnhart said that the DEA's time is too valuable for these constant distractions. And by constant distractions, he meant protected activity.
Right, the fact that she was trying to get accommodation, it was distraction, right?
Exactly,
right.
Exactly right.
And never accommodated her at all, right? She went to the EEO office of the DEA herself, right?
Absolutely. Appellees have told her that this accommodation was impossible for any number of reasons, and that ended up simply being untrue. The DEA EEO office, when they were approached, took care of this for Ms. Smith, even though appellees had said that it was impossible. Beyond that, the DEA's counsel mentioned that the fact that Ms. Quinn lied in her affidavit was not relevant to the question of solely standard under the Rehabilitation Act, but it absolutely goes to pretext. The documents show Ms. Quinn found out about the informal EEO complaint that Ms. Smith had filed on June 2nd. She not only found out about it, but the documents show she set up a meeting to discuss it. And then 7 days later, she revoked her security clearance, functionally terminating her.
Within 7 days of finding out about her complaint, she was fired.
Yes, that is extraordinary temporal proximity. We have the documents to show she had knowledge, and we have the documents in the form of her affidavit that show she lied about that knowledge. It is at minimum a disputed issue of material fact, and I think a lot clearer than that.
So, Mr. Ehrlich, can I stop there, because I think the Chief Judge Gregory's question and your response are important. There is close temporal proximity here. You know, one thing that's different though about these cases, all these things are pretty close in temporal proximity. So whereas lots of times you have an event that, soon before a termination that involves things that have gone on for a long time, here a lot of this came together pretty close to the time she was terminated. And maybe that makes it a genuine issue of material fact. But does the word solely in the Rehabilitation Act matter? It seems to me that's a pretty important causation standard that we have to consider in the question of whether there is a genuine issue of material fact. Help me with that.
Absolutely, Your Honor. And I think we can meet the solely standard. And let me give you a couple of other bits of evidence that help us there. Scott Barnhart, in his deposition, said that the reason Ms. Smith's clearance was pulled was that she needed to show up to work. I don't have any reason other than that. And she didn't show up to work because she could not, because she was not accommodated in a way that would let her come to work.
And that's in the record, correct? You gotta make that's yes. In the record, and that's their own, and that speaks to solely, does it not?
Absolutely, it does. And Scott Barnhart in his deposition also said the government asked that she show up to work and she's not showing up. We're big people here. We're professionals. If you can't do what the expectation and the role requires, maybe you should go elsewhere. And again, she wanted to do exactly what was required, but could not because she could not get the accommodation she needed.
Okay, but what about the parking space? How does that play in time-wise here? Are you saying we totally discount the fact that they did give her the parking space because there was the time period that elapsed? Or it seems to me at the time she was terminated, she did have a parking space and she wasn't showing up. So how do we deal with that?
Well, there were just a few days there, and I would need to check the record to confirm whether she came into the office after June 5th. But the decision to terminate her had already been made at that point.
As a matter of fact, Mr. Ehrlich, you said they put the termination decision on hold or something like that already, correct?
Yes, so they made the decision on June 4th. They found out about the accessible parking on June 5th. I don't believe Ms. Smith ever actually received the accessible parking tag because just a few days later than that, just 4 days later, her security clearance was revoked, and then she was functionally terminated.
She didn't have enough time not to show up after she got the pass, basically.
That's exactly correct, Your Honor.
Remember, this is summary judgment. We at appellate courts, we can't decide it based on, so this is an important thing. That's why these points to protect people who are otherwise able in the law and those types of things, correct?
Absolutely, Your Honor. I think at absolute minimum, these are disputed issues of material fact. In fact, I don't see how it's possible that the DEA could concede that joint employment was too close of a call to even move for summary judgment on, and CSRA argued that it's something that should be granted where there's no disputed issues of material fact. It is a joint analysis between the two entities. There are disputed issues here, and only a fact finder should be addressing.
Okay, but they can't concede an issue of law. If we say that their analysis is entirely wrong because she was a self-proclaimed independent contractor, then it doesn't really matter what they conceded about joint employment. If we say the DEA wasn't a joint employer, might have been, because that wouldn't matter at all, would it?
So if that's the finding that this court reaches, then that is the threshold question. But again, I will just highlight that Garrett and Butler and all of their progeny, obviously much more with Garrett because it's a 40-year-old case, all look to the economic realities. And while they note the intention of the parties, it is the 11th and least important factor. Everybody in this case, all of the parties could have said and signed as much paperwork as they wanted that she was an independent contractor, but that is only one of many factors that go into the decision of whether this court actually determines she was an independent contractor.
As a matter of fact, it's a mixed question of fact and law, isn't it?
That's right. The sort of which I don't see how it could be determined on summary judgment, Your Honor.
Okay, do you know of any cases in any other circuit, Mr. Ehrlich, where somebody was a self-proclaimed independent contractor, not just the intent of the parties, but that they signed a statement saying, I'm an independent contractor, and a court of appeals nevertheless held that they were entitled to argue that they were an employee under the Rehabilitation Act? Do you know of any cases anywhere? Because I couldn't find any. So that's what I'm interested in.
Your Honor, I don't recall if in Selena, Luna Reyes, or AT&T, any of those individuals signed a document saying that they were an independent contractor. But as I mentioned, all of those were cases where they were ultimately found to be employees and joint employees. The answer to your question is no, because we have not. I have not looked at that. I thought we had sufficient in-circuit authority. But if the court's interested in supplemental briefing, we'd be happy to put that together.
I mean, we draw from analogies, don't we, in other places that, for example, in terms of work and exempt and non-exempt employees, and if an employer just call everybody exempt, we don't just take by the label, do we? We look at what they do and what's the control, do we not?
Absolutely. That's the nature of the hybrid analysis, right? It is not just an economic realities test or just a test of the formalities.
All right.
If there aren't, I was just going to say, if there aren't any more questions, then I thank the court for listening to us today.
All right. Thank you, Mr. Ehrlich, and thank you, Ms. Levinson, and thank you, Mr. Ward, for your presentation. We appreciate it. We can't come down and greet you as we do in our normal Fourth Circuit tradition, but know nonetheless that we appreciate your presence and your contribution to help us decide these difficult issues. Be safe and stay well. Thank you.
Thank you, Your Honor.
Thank you.
Thank you. Mr. Jacob?
Yes, Your Honor. Okay to proceed?
Yes, you may.
Good morning, Your Honors. May it please the court. This case comes before the court on a denial of the plaintiff's motion for summary judgment and a grant of the defendant's motion for summary judgment. Within the appeal, there are also a few evidentiary issues that were raised. And so what I'd like to do is go through some facts first, at which time I'll deal with the evidentiary issues, which I don't believe are the main focus or the main issue at hand, and then deal with the significant issue, and that being the lawfulness or unlawfulness of the ordinance in question. Apologize here. Thank you. All right. First of all, the town of Ocean City, Maryland, has approximately 7,800 residents and about 8 million visitors yearly. And the 8 million is comprised of about 32% from Maryland, about 34% from Pennsylvania, about 10% from West Virginia, Ohio, and Connecticut, and 24% from Virginia, New Jersey, New York, and internationally. And this is important in the context of this case because we're going to talk about the public moral sensibilities that this ordinance was targeting. And in a sense, it's not just targeting the residents, 7,800 residents, but rather the 8 million. Now, Ocean City did adopt an ordinance, that being Ordinance 2017-10. That ordinance incorporates within it a gender-based distinction that was on the basis of protecting the public sensibilities.
So, Mr. Jacob, if I could just stop you with what you said right before that, is it your position that in considering whether the moral sensibilities are offended, you don't look to the residents of the locality, but look to the sensibilities of the visitors?
Well, Your Honor, we're looking at as applied. This ordinance actually ends up targeting a far greater basis than the residents. But even if we just focus on the residents themselves, as the facts also show, it was a small minority of the residents that arguably their opinion was even captured. Well,
I'm just trying to make sure I understand what you're saying the test is. I mean, I understand that you could say that people affected by the ordinance, whether they, what they can wear or not wear, could be people who are outside the municipality. But is the test about whether the ordinance offends the moral sensibilities, do we look just at the locality, or do we look at whoever might visit?
I think both. I think we have to look first.
What's the authority that says we look outside the locality?
Well, my point being, Your Honor, is that if in practice the ordinance actually causes discrimination, I think the Equal Protection Clause itself would say that it cannot stand. But to answer your question directly, I do believe that Your Honor is correct that in passing the ordinance, one would look to the locality itself, Ocean City.
Okay, thank you.
Your Honor, prior to enacting the ordinance, which targeted the female bare-chestedness, Ocean City did not conduct any investigation, did not conduct any public hearings, did not consult peer-reviewed articles, did not conduct public surveys. They did not consult with experts or consult with other jurisdictions regarding any effect that this type of ordinance would have. Ocean City admits that it didn't conduct any survey on how it would impact the tourist industry or what impact would happen in the event that the ordinance was not there. What we do know is that there were plaintiffs who testified that they had been bare-chested on the beach and there was no disorder prior to the enactment of the ordinance. There's been a claim, or there's been a lot of discussion about striking down this ordinance would support the minority view, but in reality, it's a specious argument because there are only few cases in the nation that are even brought. In the majority population or the majority of the states, we don't see these laws even being enacted to therefore be challenged. Notably, the 10th Circuit, which actually governs 6 states, has decided that such an ordinance cannot stand. Basically, this came as a result of complaints to public officials from a few hundred people at best. But as we saw in the facts, those complaints were not properly documented. It's not clear whether there were some positive comments that may have been lost along the way. I won't belabor the point, but I think the record's pretty clear on that point. With respect to the evidentiary issues, those go to who can opine on the public sensibilities and who cannot. The judge did give way to Mayor Richard Meehan and Councilwoman, I believe it's Mary Knight, I apologize if I have her name wrong, basically saying that they could testify as to what they believe to be the public sensibilities. But when asked what their qualifications were, the mayor said that he was elected, lives in Ocean City, and he listens to what people bring to his attention. He doesn't have any specialized training in that regard. And Mary Knight explained her qualifications as the fact that the way she was raised, that she was family oriented, and that she has a Catholic background and that she has an education from Loyola. But basically she said, I'm pretty good at understanding when somebody has a concern. So essentially there's no specialized training that these individuals had in order to properly evaluate and weigh. There's no qualitative, quantitative, empirical data that these individuals were, number one, qualified to collect, and number two, analyzed with respect to coming about and passing this ordinance. In contrast, we have Debbie Herbenick, who did talk about the effect that such statutes do have and how it undermines the very purpose of the statute, which is to protect. So statutes of this nature, they are governed. It's our argument that the Equal Protection Clause of the 14th Amendment is supposed to protect everybody with equal protection under the law. But in this case, Ocean City has used the Equal Protection Clause to justify the existence of an ordinance that's based on a sexist ideology that has been proven to hurt women and children. This is the very reason that we have a heightened standard, that being the intermediate standard, that the courts have guided us to say that, hey, we need to be very careful that we're not letting improper, unlawful reasons creep into the law. And the law is riddled with situations where that has occurred that the courts have reversed. I mean, keep in mind, when our nation was founded, this Constitution, it was for white men, landowners. Initially, it offended the public moral sensibilities to have women vote, to have Black men counted as people. So the fact that something may make other people uncomfortable is not a reason for a classification to continue. The fact is, yes, people will be made uncomfortable as we continue to provide equality under the law. We see that with gay marriage. We see that even now we're seeing what's going on is the public is demanding equal protection under the law when characteristics serve as the basis for discrimination. We're seeing that right now around the nation with an intent or an effort to eradicate systemic racism, which I understand is a different issue, but I'm just saying the public has consistently been demanding more and more equality under the law, but here this government objective that has been recognized, the public moral sensibilities, is an amorphous term that nobody seems able to really define. And when we look behind, well, what did that mean to Ocean City? We find that it basically meant that people were uncomfortable. This takes me to this court's 1991 opinion of U.S. v. Biasic, which essentially handcuffed the district court with respect to how the court needed to rule based on the concept of stare decisis. The court noted that basically, like it or not, this is the law in this district. But importantly, even Biasic understood that at some point the public is going to mature and progress. And you know, I believe we are there, but I also believe that this standard that has evolved is being misused to circumvent the very thing that it was intended to protect. And that's, again, that public morality opinions are creeping into the law, but for an improper basis. And in fact, when we actually look back at the Biasic ordinance, the preamble said that it was deemed necessary to prohibit certain conduct in order to secure and promote the health, safety, and general welfare of the county's inhabitants, whereas this ordinance says one does not have a right to impose one's lifestyle on others who have an equal right to be left alone. Ironically, the ordinance is doing just that. It is imposing the lifestyles, the opinions, the sexist ideologies of a very small group onto the masses, onto the majority. And again, you know, that it's not, we are not supposed to be implementing a morality code, but that is exactly what is happening here. There was really no objective in the passing of this statute, ordinance. They said that when questioned, they were not targeting any special issue or problem particular to women. They were not targeting any potential deleterious effects or secondary adverse effects that might happen. They did not, again, they didn't conduct any research and then target some health problem. They did no investigation into whether it could even harm children or promote a rape culture or negative impact on a female body image or negatively impacting breastfeeding rates, all of which Debbie Herbanek or Dr. Herbanek, her unrebutted opinion, mind you, pointed out that this ordinance does essentially the exact opposite of what it purports to do. And really interesting was that there was even an admission that the ideology crept in, because when they were talking about the public sensibilities and moral sensibilities, they were asked about the sexualization of the female body, and there was an admission that it might be part of the issue that the sensibilities revolved around. Ocean City understood that the sexualization of the female body could have been one of the reasons for the complaints, but they never explored that. They never explored if their complainants, if their family values and moral sensibilities were simply archaic. Were these people who wanted this law because they believed that women should be barefoot and pregnant in the kitchen, or whether whether women should be permitted to drive, or whether they should be wearing a burqa in public and walking 6 feet behind men. None of this was explored, the whole reason for why these complaints even came about. And there's a duty and a responsibility on our public officials to make sure that what they're purporting to fix is actually a problem, and the objective that they are using actually fixes the problem. And this brings to another issue, the fact that the statute, the ordinance is overly broad. It talks about gender and sex. It conflates the issue into one, but our society has progressed and now understands that sex is designated at birth through genitalia identification, but gender is something much more deep. And here, you know, how is this going to be applied when there's a transgendered person who identifies as male but has a female physical features? Mind you, the differences are really small. Yes, there are female breasts that are large, but there are male breasts that are equally large, and there are females who have a flat chest, and there are males who have flat chest. There really is no outer distinction between the two. There's an inner mammary gland, but that can't be seen, but is functional in the females and usually not functional in the males. I'm out of time, but of course I will answer any of the court's questions.
All right. Thank you, Mr. Jacob.
Thank you.
Mr. Bright?
Yes, thank you, Your Honor. May it please the court, Bruce Bright on behalf of the town of Ocean City. And if Your Honors have any questions, I'd be happy to start there. If not, I will discuss very briefly the evidentiary issues that arose below and on which the trial court ruled. Hearing no questions, I will proceed to that. The first issue is whether or not the trial court abused its discretion when it denied as moot plaintiff's motion to exclude purported expert opinions of Mayor Rick Meehan and Councilmember Mary Knight. This motion was denied as moot in essence because their testimony did not include any expert opinions. They were never identified as expert witnesses. They were never proffered as expert witnesses, and their testimony was only fact testimony and to some degree lay opinions, and more particularly on the subject of what the prevailing public moral sensibilities are in Ocean City as it relates to one subject, and that is whether or not exposure of the female breast still does and should constitute nudity and be regulated as such. So you have Federal Rule of Evidence 702 that governs admissibility of expert opinions. Of course, Rule of Civil Procedure 26A2 that governs disclosure of expert opinions, and then you have Daubert and the other cases. None of that applies to the court's ruling on this particular issue because Councilmember Knight and Mayor Meehan were not ever proffered and did not testify as expert witnesses. There is the related evidentiary issue.
But you said that they were allowed to give opinions.
Yes, Your Honor, they were.
What authority do you have for lay people or anybody else other than an expert to give opinion? They're fact witnesses, aren't they?
Well, there are fact witnesses, and the authority that I would give would be Rule of Evidence 701, which governs lay opinions and provides that a witness not testifying, or certainly they were not, they testify in the form, may provide testimony in the form of an opinion if it is rationally based on the witness's perception, and I think the record is clear that their lay opinions were rationally based on their perception of what the...
All right, let's get to the rational. What is so? How many people did they talk to?
Well, the testimony was, and of course this testimony was unrebutted, was that as soon as some discussion of how this issue arose may be useful here, but there was one of the plaintiffs in this case approached the state's attorney's office and the Ocean City Police Department affirmatively, proactively approached those two agencies in late 2016, early 2017 to inquire what their position would be on the subject of female toplessness on the Ocean City beaches and the Ocean City generally. The state's attorney referred that matter to the AG's office for some guidance. The Ocean City Police Department, of course, waited until the state's attorney and the AG's office took a position. But when that occurred, there was a lot of reporting in the media about this issue, and along the lines of, Ocean City.
You're trailing off, counsel. I can't hear you.
I'm sorry. Can you hear me now?
I hear you now.
Okay, I apologize. There was reporting, pretty extensive reporting in the media, Your Honor, after this question was raised, and then the state's attorney went to the AG's office about it, and the reporting was along the lines of the Ocean City beaches may become nude beaches. Well, as soon as that story made it into the papers, there was a significant public hue and cry over this issue, and the mayor and council began to hear from many people, and what they testified to was they received many emails, and approximately 100 of those emails are in the record.
100.
I'm sorry?
You said 100?
Approximately 100, yes.
All right, go ahead.
Beyond that, and of course, the mayor and council are well known in this community as the mayor and council, and everywhere they go publicly, people may walk up to them and raise public issues. They both testified that many places they went, this issue was addressed and raised, and they were asked for their views on it. They also received many phone calls, and the mayor is in the habit, as was, and Councilmember Knight is no longer on the council, but when she was on the council, they were both in the habit of taking calls from whomever is a citizen in the community.
So I assume that there are no numbers to these calls and people coming up to them, correct?
We don't have measured and recorded numbers as to the calls. We do have numbers as to the emails, but we have their testimony to that effect. And I think it's important to note what Judge Bradar held was, by virtue of their position, both under the charter and otherwise, by virtue of their position as elected officials, their job is to take the temperature of the public on a whole host of issues, this being no different than other issues where they evaluate what the public view is and then they legislate on that basis. That's what city councils do. That's what county councils do. That's what they did in this case. And they waited, however, some length of time for the AG's opinion. That took a long time. They then passed, because it was the beginning of a season, and as I said, this issue was getting a lot of attention and focus, and there were a lot of upset people communicating with the mayor and council. They took the step to pass an ordinance at the beginning of the season. And then, coincidentally, within about a week after that, the AG's office issued its determination, not in the form of an AG's opinion formally as such, but in the form of a letter from an assistant AG to the effect that the AG's office believed the Court of Appeals would find the ordinance to be constitutional under equal protection analysis. So that reinforced the legislative decision that they made, but it did not predate the legislative decision that they made. And the court went to some length.
So this law came into effect because someone asked about what they would do if they expressed their freedom in this manner on the beach.
It all began, the sequence of events, yes, Your Honor, began with Chelsea Alina.
So I guess this moral sensibility was of recent vintage, right? Because you didn't have a statute before someone asked the question. Is that right?
No, Your Honor. What I would say to that is that the prior to then, the mayor and council, apparently anyway, did not see the need to specifically legislate on that issue because the sensibilities were what they were and people conformed themselves to that. Well, now you had, in the more modern era, someone come along saying they wish to go topless, or they wish to go topless on the beach in Ocean City. That necessitated addressing that issue legislatively through the adoption of the ordinance. But we don't take the position that the sensibilities of the public, the moral sensibilities of the public on this issue, relate to any recent events or arose only because of recent events. It's just that the issue surfaced as an issue for legislative concern because of the events that predated the adoption of the ordinance. But the sensibilities of folks in Ocean City is and has always been consistent with what's reflected in the ordinance, and the ordinance is very clearly adopted to protect.
Well, you're testifying now, counsel, because what you just told me the basis for my question was what's the rational basis. You don't have anywhere near a fraction of 7,800 people. Basically, it says 100 people who wrote something, a document, and wherever the mayor, those two people, their paths were in telephone calls, we don't know. Are we to assume that everyone who didn't call is in favor or have no such moral sensibility?
I don't think you can make that assumption.
Why not?
Well, I would say this, Your Honor, that there was testimony from Mayor Meehan and Councilmember Knight to the effect that nobody came forward to them, either by phone or in person or by email. Nobody came forward to them. There may have been one or two emails. I want to be clear on that. But nobody came forward to them otherwise in support of the idea of female toplessness on the Ocean City beach. And
Well, it didn't have to be. You just framed the facts. You said it was widely done in the news, and you said it was reported that we may have topless beaches in this town. Well, then the fact that they don't come forward would suggest that, okay, so big deal. Why is that not a reasonable, to make conclusion to make?
Well, the mayor and council, when they legislate, they must have an understanding of what the public will is, and they don't always. There are many questions on which the mayor and council legislate where they do not conduct detailed studies, analysis, and take polls before they legislate on a question affecting public interest and public concern.
Was there a public hearing?
There was a public. Nobody spoke opposed to it. There were a couple of people that spoke in favor of the ordinance.
Nobody spoke opposed to it. I wonder how long it would take you to get around to that. Nobody spoke to it. That's the form which they exempt you. It's amazing.
Well, I want to be clear. Nobody spoke opposed to the ordinance that was being adopted.
Right.
The only people who spoke at that hearing, and there were one or two, I believe, spoke in favor at some length in favor of the ordinance.
Right. Two people.
Yes, Your Honor, and of course that meeting was publicly disclosed. If there were widespread public sensibilities in favor of, I guess I would look at it this way. There's no question that still today, under equal protection analysis, protecting against or protecting public moral sensibilities has been and is an important governmental objective under Supreme Court and other jurisprudence. There's no question about that.
I'm glad you mentioned Supreme Court. You're familiar with Lawrence, aren't you?
As you state, Lawrence, I couldn't tell you what the case is about, but Your Honor.
You don't know what the Lawrence case is with the Supreme Court?
I may well know, but as you're asking me, I can't recall what Lawrence is about.
Okay.
But I would cite the Craig versus Bourne.
I was just talking about how we've progressed. You said you included Supreme Court. It's.
Yeah, is Lawrence the case in terms of equal protection of transgender folks? And is that the recent Supreme Court case that you're referring to?
No. What about in terms of consenting adults, in terms of sexual behavior between them? They can't be legislated.
Well,
they prohibit those things, and all those laws that they had, like sodomy and all those things like that, they had to go across the board. It's a different, and I raise it because you said the Supreme Court, and you started there. We're just not in the same Neanderthal type environment.
I agree with that 100%, Your Honor, but this is not regulation of sexual behavior or sexual choices or sexual, issues at all. This is a regulation of public nudity, and whether or not public nudity should still be defined as including exposure of the female breast. There isn't any question that today and at all points in time, the Supreme Court has said that regulation of public nudity to protect the important governmental objective or to advance the important governmental objective of protecting public and moral sensibilities is perfectly constitutional. Really, the only issue before Your Honor and the other members of the court in this case is whether exposure of the female breast should still be included within the definition of nudity. Regulation of or prohibition of public nudity.
Well, we're not talking about nudity here because we have to reach that. This is about equal protection and how it falls differently on men and women. That's understood.
Yes, Your Honor. Yes.
So in other words, the point is that you say a lot of people think it's immoral for a woman to have her breast shown on the beach. That's immoral?
Well, I would phrase it differently than that people think it's immoral for women to show their breasts. The public sensibility of the residents of Ocean City is that the public moral sensibility is that they don't want to see nudity, and they define nudity as including exposure of the female breast. So there isn't a morality issue beyond that. It's that equal protection analysis allows a legislative body to pass legislation that serves an important governmental objective and is substantially related to achieving that governmental objective. And here,
counsel alluded to those, and Mr. Jacob mentioned a prior type of sensibilities. Like, it wasn't until 1970 that, Loving versus Virginia, that miscegenation laws, which people felt it was immoral for people of different races to marry. Wasn't that a moral? Was it not defended on moral basis?
Absolutely. Understood, Your Honor.
Understood what? Was it the answer? Yes, it was moral. Wasn't it? They thought it was morally sensible to that, and a moral sensibility.
I believe so, Your Honor. And obviously that was a view that was not proper ever and did not survive the test of time.
Did you say it obvious and never was?
Was never proper.
Never proper? Right. Never proper. It went a long time, 1970, and that's how much past the 14th Amendment, the 13th Amendment? That's a long time.
Understood. But in this case, there hasn't been any evidence presented by the plaintiffs in this case that would reflect that the public sensibilities toward this category of public nudity, which is exposure of the female breast, has changed as in comparison to what it was in 1991 when the OXIC was.
But it couldn't. Part of it was to, Judge Qualibam asked the question, is it limited to just community and what authorities that is? Well, evidence can come in. It doesn't necessarily have to be the sine qua non of the question, but the broader question, why is it not relevant what other people beyond the confines of your fair town think about it? That's in a context. It doesn't have to be dispositive for it to be admissible.
I guess I would agree, Your Honor, but there wasn't even evidence to that degree. There was no evidence of any views nationally, statewide, within Ocean City or otherwise, public sensibilities toward this subject of exposure of the female breast, other than the evidence put forward by the town of Ocean City. There was no evidence put forward by the plaintiffs that rebutted that or that told a different story in terms of what the public sensibilities may be on this subject. In fact, their proffered expert testified there was no such study on the subject, either nationally, certainly not in the state of Maryland, or in the region. So there wasn't any evidence at all presented by the other side on the subject of what the public sensibilities were. And I think the court's ears were open to hear that evidence if it existed and if it was presented. And we were certainly open to respond to it if it had been presented. But there was no such evidence. All of the evidence presented in the record below was to the effect that public sensibilities, the public moral sensibilities of the town of Ocean City still did not accept public nudity to include exposure of the female breast. So you really had a one-sided record. And under the OXIC is precedent. It is this court's prior ruling. Obviously, it can be overturned by this court, but under the doctrine of stare decisis, there isn't a record in this case on which to overturn the ruling of this court in the OXIC. And then you have of course the rulings from the other circuits that all support the finding of Judge Berdar below on equal protection analysis, including very recently the Supreme Court of New Hampshire in the Lilly case and the Eighth Circuit in the Springfield case. The only different outcome is the 10th Circuit's decision in the Fort Collins case. In that case, we've addressed this in our briefs, but that case is clearly distinguishable because the municipality in that case provided different justifications for the ordinance that they passed. The court held that the ordinance was not substantially related to achievement of those particular purposes. In this case, we have a different purpose, which is the protection of the prevailing moral and public sensibilities in the Ocean City area. With that, unless the court has any other questions, I will stop my argument.
Thank you, Mr. Bright. Mr. Jacob, you have some time.
Thank you, Your Honor. First of all, with respect to the last comments by Attorney Bright, actually the record was hardly one-sided. Dr. Debbie Herbanek actually did provide opinions on this issue, and I discussed those in the brief. Basically, the court wanted to, I only have a few minutes here, but pages 12 and 13 of the brief identify those various opinions that she held. This case is about the agency of women to decide for themselves what they do with their body and when they're considered sexual objects and not. The fact is, men were not permitted to be topless as recently as I believe it was the 20s or 30s, and had to fight for that right. And now it's not a big deal because nobody has been killed by a breast. One of the first things that a baby sees when they're born is the female breast. And it's interesting that while we have artistic expression and we have exceptions for breastfeeding, everybody's safe when those events occur, but suddenly it's incredibly offensive when the breast is removed from a baby's mouth and put back into a shirt. The real problem or question with respect to Debbie Herbanek, it goes to weight and credibility, not admissibility, and not to qualification. Her opinion should not have been struck. But I think, Your Honor, I think you hit the nail on the head. 2 of 7,800 people made a complaint, and we don't have any evidence here, despite the city's or the town's burden of proof to show the validity of the or the validity of the ordinance. Nothing was put in.
Counsel, why do you? I mean, I think you're right that at the public hearing there were 2 people who spoke against. Yeah, and we could debate what that means. I mean, some people would say the absence of any when an ordinance is being proposed to restrict suggests lack of support. Maybe you could say the other, that the lack of more than 2 means no one really cares. I don't really know how to do that. But don't we also have the evidence of the 2 officials who talked about the documented emails and then talked about phone calls and interactions beyond what's documented?
Sure.
And so, I mean, I think it's a little unfair to say you got 2 people. You have 2 people who were elected to represent the folks who talked about what's documented and what's beyond that. Now, we may think it's, good or bad what they think, but the question is what's the moral sensibilities? And, I'm just trying hard to figure out why that evidence doesn't count towards that, despite, the kind of philosophical points you're making.
Well, Your Honor, I hit on basically both points that you raised. Number one is these officials being elected. They were elected, but once the stated opinion of the mayor came out, he actually received fewer votes and was elected by less than a majority of the people. So that is telling in and of itself. When he was trying to say, hey, I was elected, therefore they support this issue. Going to the other question, the evidentiary question, I'm sorry, first as to the election, pages 10 and 11 of my brief discussed that issue. Pages 6 and 7 address the other issue that you raised, Your Honor, and that is, let's give them the benefit of the doubt. Let's just say that there were, as we were able to, I tried to pull it out of them, but on the record being conservative, they had 150 complained by email or telephone. I think they said 300 to 500, because they didn't really log them well, complained to the mayor in person. And they didn't log who those were. We don't know if they were visitors. As Your Honor pointed out, we don't know if these complaints were visitors who came into town or whether they were residents of the town. There was
Right.
there was simply no logging of this evidence, so it could even be tested. But really, Your Honor, what this comes down to is the fact that everybody deserves equality under the law. And while the other case that they referenced, the 10th Circuit case, while it was different factors or government interests that they were looking at, it circled right back to the fact that what was really going on was this was an attempt to legislate morality. And that's exactly what's happening here, only even more blatant in this ordinance. Thank you, Your Honor.
Thank you so much, Mr. Jacob, and thank you, Mr. Bright, for your arguments. And appreciate that. And we can't come down and greet you, but please know that we very much appreciate your arguments and help in this case. And wish that you would be safe and stay well. Thank you.
Thank you, Your Honors.
All right. Mr. Akisha?
Kesha, Your Honor.
Okay. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court. Michael Bekesha on behalf of appellants Sharon Bauer and Richard Georgina. Appellants are Montgomery County, Maryland taxpayers seeking to prevent Montgomery County officials from illegally expending Montgomery County taxpayer funds. There is no dispute that taxpayer claims in Maryland are well recognized and long established. For a taxpayer to prevail on such a claim, a taxpayer must show that she's a taxpayer, that she brings a case on behalf of all taxpayers, that a public official's action is illegal, and that official's action results in pecuniary loss. Here, the only disputed element is whether appellees have acted illegally. Although this court may reach the merits, it's not the primary issue currently before it. The issue is whether appellants have brought a valid state law claim, and that's where I'm going to begin my argument. Although the federal courts rarely hear such claims, Maryland courts and at least 35 other state courts hear taxpayer claims frequently. A taxpayer claim is an essential tool of democracy, allowing taxpayers to challenge actions of their government officials and hold them accountable. As Judge Keenan stated while she was a Virginia Supreme Court justice, the right of taxpayers to challenge the legality of expenditures by local governments is a right permitted in almost every state. In addition,
Counsel, can I stop you before you get to the cause of action part and talk about jurisdiction? And I'm not so much interested in the 1331 jurisdictional argument. I'm really interested in the Article 3 standing, which we must have. And as I've looked at that, you have kind of a case over 100 years old, Massachusetts versus Mellon, which at that time talked about municipal taxpayers may have standing, but we got a more recent case, the Daimler Chrysler case, that really deals with state taxpayer standing, and that whose logic to me seems pretty applicable here. Could you address the issue of not state court standing? I know Maryland says you have standing in state court, but Article 3 standing in light of the Daimler Chrysler case.
Yes, Your Honor. As we see it, it's in federal court, it's clear municipal taxpayer standing still exists. The Supreme Court hasn't said when a taxpayer is suing a municipality that there is no standing. The Supreme Court and the circuit courts have said when suing a state, there is no Article 3 standing. That's correct. Here we have a county, and as far as we can tell, counties are other circuits are treating counties differently. Sometimes they're treated based on the state law more as a municipality. Sometimes they're treated as a state. There is no Fourth Circuit precedent on that. There isn't Supreme Court precedent dealing specifically with a county, Your Honor. So in our view, Montgomery County is more like the local office, a municipality, and less like a state because it has a limited number of residents. Does that answer your question, Your Honor?
Well, yeah, I appreciate your answer. I'm not sure it answers it, but I don't need anything else from you. Thank you.
Thank you, Your Honor. So as I was saying, looking at this as a state cause of action, the state of Maryland, it is clear, the state of Maryland has a cause of action of taxpayer claims. And unlike federal court, the taxpayer standing claim provides both the standing as well as the cause of action. And so unlike federal court, where you also need to address a private right of action or a cause of action, Maryland law does not require that. It does not require a separate private right of action.
How do we know, counsel, that it applies to unlawfulness under federal law? On the one hand, you have broad language in the cause of action that doesn't say it doesn't apply to federal law. I get that. But all the cases I saw in Maryland involved alleged unlawfulness under state and local law. So how do we know that in Clyde, and we're sitting here in diversity trying to figure out what this cause of action means, how is it so clear that we would say unlawfulness under federal law applies? And related to that, should we certify that question?
Those are good questions, Your Honor. I would point to two 1966 cases by Maryland's highest court, specifically Murray v. Comptroller of the Treasury, where the Maryland's highest court found that a taxpayer claim could be brought when the violation was the federal Constitution, the Establishment Clause. And at that point, when the court ruled that, the Supreme Court and federal courts had not determined that the Establishment Clause was essentially self-enforcing, that there was a private right of action under the Establishment Clause. At the time, there was no private right of action when it came to enforcing the First Amendment. And
but counsel, isn't there a distinction here, though, where a court is enforcing a person's constitutional rights rather than asking the state to intervene and create a cause of action regarding a federal statute? Isn't that different when you're talking about a right being vindicated, being a citizen's rights under the United States Constitution, as opposed to simply a federal statute for which Congress did not create a right?
No, Your Honor, because now the Establishment Clause, now the Supreme Court has recognized that courts can vindicate constitutional rights. The Establishment Clause is a little bit unique, but you also now have Section 1981 that provides the private right of action to vindicate federal constitutional rights when it comes to local government officials. But that wasn't always
but excuse me, counsel. What I'm saying is you've got a federal statute that doesn't create the private right of action. And you're saying the state can create the private right of action without any basis for doing so. Just they can say that our common law allows this, no matter what the statute says. Because see, the state is bound by the US Constitution, there's no question. But here, it seems to me that you're trying to create a private right of action to enforce a federal statute when Congress has not seen fit to do that.
Appellants don't seek to enforce a federal statute. Appellants seek to prevent local government officials from spending their tax money unlawfully. It's the violation of federal law is just an element of the claim. You know, it's very similar to negligence per se claims and other claims that states have developed related to the Federal Food, Drug and Cosmetics Act.
Well, so counsel, taking that argument and running with it a little bit, I mean, you may be right. States are separate sovereigns. They can create their cause of action, and there's some authority for barring federal standards in negligence per se and other matters like you're talking about. But it seems like at least one barrier to that is the supremacy clause in preemption. And I know we don't have any express preemption, and it doesn't sound like there's an alleged field preemption. And I'm not sure anybody ever calls it preemption, but the government finally, after no one else talked about it, brought up the Arizona versus U.S. case, which talks about implied conflict resolution or implied conflict preemption. Why does that doctrine not prevent you from asserting the state cause of action?
You know, U.S. v. Arizona, the sections there were very different than what we're talking about here, Your Honor. For example, one of the sections that the government brings up concerned Arizona seeking to create criminal penalties for unlawfully present aliens that got jobs, that sought employment. The reason that the Supreme Court found that that was preempted was because Congress had determined to only criminalize the employer, not the employee. And so there were enforcement mechanisms in place to enforce those specific provisions. Here, Congress didn't create any enforcement mechanism whatsoever when it comes to Section 1621.
And that's a good distinction, and I hear you there. But when the language says conflict and method of enforcement, it is choosing not to have a method of private enforcement, in effect, a decision on the method of enforcement?
I don't believe it is, Your Honor. I think that this court has been clear that when it comes to preempting state claims, that the presumption is always against preemption. And so looking at 1621 and looking at this long recognized common law right for taxpayers to challenge the expenditure of government actions, there would need to be more. There would need to be more than just maybe there could be potential conflict in the future. I mean, there's no reason why 1621A could potentially maybe be enforced by the federal government, but also this common law claim go forward. There doesn't seem to be the tension here that there was with what Arizona was doing with their numerous provisions related to immigration. Arizona was creating criminal penalties and other civil violations where Congress had decided to also create criminal penalties and civil violations. That just isn't what we have here, Your Honor. And it's very similar to, the Federal Drug and Cosmetic Act cases. And I believe Your Honor had one of those cases when you were a district court judge. You had this idea that damage remedies for claims that are based on violations of FDA regulations are not preempted in state court. And so these are very similar. This claim is very similar to those types of claims. And the federal courts address those and deal with those on a regular basis and don't have a preemption concern. I guess I'd also like to add regarding taxpayer claims. I believe every state in this circuit has such claims, and to my knowledge, neither the government nor appellees have pointed to any cases that, not only just in Maryland, but any of the other cases in which the state courts there have rejected the notion that the underlying statute, that the action is unlawful because of a federal statute. There is no evidence of that. The states have filed amicus briefs. 11 out of 13 of the states, including the District of Columbia, all have a form of taxpayer standing, and none of them made the point or made the argument that taxpayer standing doesn't exist in their states, or even that that taxpayer standing or taxpayer claims can rely or cannot rely on a violation of a federal law. The states just have not made that argument, and I imagine they would have had that been an argument that was available for them to make. With respect to the subject matter jurisdiction, whether or not federal courts should hear these types of claims, we respect and understand that that's a close call. It was such a close call that, at the district court, we didn't raise the issue, but we wanted to raise the issue here because we believe this court has an obligation to do so and wanted to make sure that we addressed the issue so this court would have all the information necessary to decide that issue. I would note that federal courts, as I said, don't usually hear these cases, and all the states in the circuit have these types of claims, and so we believe it's important. It would interfere with the balance between the federal and state judiciaries for the federal judiciary to hear these types of cases. If you have no other questions at this time, I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Bekasha. Ms. Powell.
May it please the court, Lindsay Powell for the United States. There are four main parts to our argument here. First is that the court should affirm on the grounds decided by the district court that plaintiffs lack a private right of action to enforce this federal statute. Second, if the court disagrees with that and decides that it's necessary to reach the merits here, the court should remand to allow the district court to do that in the first instance. If the court were to instead reach the merits, it should rule on statutory grounds that the county law here does not meet the terms of section 1621D. First and most straightforwardly, because it does not affirmatively provide for eligibility for benefits as the statute requires. And second, because it is not a state law enacted by the state. Neither of those conclusions, and this is the fourth point of the four that I outlined, raises any 10th Amendment concerns. I will begin with those in order until the court has questions. With respect to the private right of action, this is fundamentally a suit to enforce federal law. What plaintiffs are asking for here is a conclusion that something is inconsistent with a federal statute. It is through and through federal, and that federal law does not provide any private right or any private right of action. Congress made a choice not to provide for private enforcement, and that choice should be honored. And
so counsel, on that issue, let's assume Maryland legislature said, we hereby create a statutory cause of action that any that conduct inconsistent with section 1621 that injures a Maryland taxpayer causes a Maryland can be pursued in Maryland courts. They adopt that they have an unquestioned cause of action. It unquestionably refers to a federal statute that does not have a private cause of action. Why can't the states do that? What about why can't a state say, even though the federal government elected not to have a private cause of action, we're going to borrow that standard and create one?
Your Honor, that gets into the conflict issues that were touched on earlier. So as Your Honor noted, in the Arizona case, and there are other cases that bring this up in various forms, there's Buckman, there's the Third Circuit's decision in Ray Commonwealth's motion to appoint counsel, which the county cites in its brief. But where there's a conflict in the method of enforcement, particularly in an area like this, and like we saw in those cases where the federal government has made a careful balancing of complex considerations. We're dealing with a law here is at the intersection of immigration law and also touches on the federal-state balance. And Congress has made a determination that that should not be enforceable by private litigants. And that's a significant choice.
So if I could find, I'm sorry to ask a question and then interrupt, but I want to make sure my colleagues have time too. So I appreciate that issue. Is that the legal barrier to what I'm saying. I mean, is the general principle that I'm saying, sure, states can do that, but you have to consider preemption as the barrier to it. And so if it's preempted, you can't do it. If it's not preempted, you can do it.
Your Honor, I'm not prepared to say categorically that there might not be other barriers. In some instances, it would be a very unusual thing for a state to do that. And I think there are reasons why states don't, but I think the preemption argument is the one that's been briefed here, and it's readily applicable here and provides a basis for decision. Taking a step back from Your Honor's hypothetical, the lack of availability of this cause of action under state law is also a basis. It's simply never been used this way, the way that plaintiffs are seeking to use it. They point to no
Sure.
where a federal statute's been enforced.
But putting that issue aside, that's why I tried to make, I get there's an issue of whether it includes federal enforcement. I addressed that with your colleague. But if putting that issue aside, we do have, he used the example of negligence per se. And if you did have a negligence per se cause of action, and the only alleged violation was the federal, say Food and Drug Administration claim, and it has no private cause of action, why is that different other than it's in a more traditionally accepted legal theory, negligence versus taxpayer standing?
The difference, Your Honor, is that there's a substantive state law in those provisions that identifies a duty in the circumstances under which you fail to satisfy that duty, and federal law merely informs one aspect of that claim. What plaintiffs are trying to do here is really just enforce federal law. This is really just about whether the terms of Section 1621 are consistent with the county's actions. So it's quite different from—
Well, there are other elements, aren't there? You got to be a taxpayer. I mean, I won't have them committed to memory like you do, but I mean, there are 4 or 5 elements in the thing, and the only thing the federal violation informs is the unlawfulness. And so, I granted that negligence is a much more accepted sort of understood doctrine, but it seems to me you got 4 or 5 elements here, and the federal illegality or unlawfulness is one of them. Seems pretty similar, unless you get into the preemption stage.
Your Honor, so again, either of these is a determinative of the issue. So if Your Honor is not persuaded on the state law analysis, the preemption decides it. But with respect to state law, the different inquiries that also bear on whether a taxpayer can bring suit under state law are not part of the substantive right in the same way as you have in the negligence context. So these are really sort of the procedural elements that go to establishing standing, not that go to, as we have in negligence, establishing whether there's a duty, whether there's causation, all the different elements of what is truly and traditionally a state substantive right. There's no independent state right here in the same way. So if the court were to disagree and believe that plaintiffs could somehow bring suit under state law here to enforce this federal right, the appropriate course of action would be to remand to the district court to consider the merits in the first instance. The merits do raise a number of complex issues, and while they have been fully briefed, the court in the common course does have the district court pass on these issues for further vetting and consideration in the first instance, and it should do so here. For the court to reach the merits, the most straightforward way to decide them is on the affirmatively provide for benefits part of the statutory text. So the statute is very clear in this respect. Not only does it require a law that's enacted after 1996, it requires that law be one that provides affirmatively for eligibility for benefits for undocumented individuals, for the individuals who are otherwise made ineligible under federal law. And I think looking at the relationship between subsection A and subsection D here is helpful, because at one point in the state's brief, they say that subsection A creates a blank slate, that it sort of wipes clear existing benefits eligibility provisions, but that's not what it does. It's a federal substantive rule. It says individuals in the following categories, following immigration categories, are not eligible for benefits. Not a regulation of the states, it's a regulation of individuals in those immigration categories, and it sets a federal default rule of ineligibility. And what subsection D says is that to change that, States have a choice to change it. Congress didn't have to give states the choice, but it did. And for states to change that, they have to follow the criteria that are set forth in the statute. And the states understand, or the county's understanding of affirmatively here rather, would really read that language out of the text. They read it to just require what they term a positive enactment, something done after 1996 that somehow in some way ends up making otherwise ineligible people ineligible, but you don't need to say so under their view. The requirement that the law be enacted after 1996 does that work anyway. So affirmatively provide for benefits, both by its terms and to avoid the issue of surplusage, clearly requires something more. And that really provides the most straightforward way to decide this on the merits. There's no real suggestion here that reading the provision that way would create a constitutional issue, and it doesn't. The law also does require enactment by a state rather than a political subdivision. That's also clear from the text of the statute. The text, Congress was very clear throughout Section 1621 and neighboring provisions where it referred to states versus state and local governments or benefits, states and political subdivisions. And the deliberate choice of Congress in that respect. The legislative history is also clear on this point, as it is with respect to affirmatively. In both instances, Congress was quite clear in saying, with respect to who must enact a law, it says that laws passed by the county, city, or other local officials do not suffice. With going back to affirmatively, it says there that the state law must specify that undocumented individuals are eligible for benefits. And I think reference to that committee report is appropriate here because it does confirm the plain text of the statute. Ours, Garage, and Mortier are not to the contrary. The statutes that were at issue in those cases were very different from the statutes, the provision that we have here. In each instance, first notably, the court did not just look at the statute and say, state typically also means political subdivision. It went through an extensive analysis, looking at the text, looking at the legislative history, looking at what the implications would be of different readings. And in doing that, what the court concluded in both cases is that where a statute confirms that the traditional powers of the state are unaffected, are not preempted or untouched, that it would make no sense to read into that a restriction on the state's ability to delegate power to its subdivisions. But that actually would not be leaving the state's powers untouched. That would be touching the state's powers. And so in the context of provisions that preserve the state's powers, the court declined to read them that way, but that's not what we have here. Subsection A touches the state's powers. It sets a federal default rule that makes individuals ineligible for state and local benefits. And then subsection D gives states a choice about whether they want to jump in and make a different policy judgment and tell states how to do that if they want to get involved. And this raises no constitutional concerns. Where states have a choice like this, the court has time and again said that the 10th Amendment is not offended. Significantly here, Section 1621A is not challenged. There's no question here that Congress had the authority to do what it did in 1621A and establish that default rule of ineligibility. So the only question is whether in taking the additional step of giving states some choice in this area where Congress undisputedly had authority to act, it somehow offended the 10th Amendment, and it didn't. Hodel and FERC versus Mississippi tell us that in areas like this where Congress has the power to act, and it gives states an option to share in that regulatory space with the 10th Amendment. One brief note on FERC is that, just as far as the details of that case go, it not only directed the states to consider the federal standards, it told them the procedures that they had to follow in doing so. So there was a command to the states. It told them how they had to consider the federal standards. And the Supreme Court found no issue with that. None of the 10th Amendment cases that are cited by the parties raise any 10th Amendment issue in cases like this, where states are given a choice. And significantly, ours, Garage, and Mortier also raised no 10th Amendment. So it didn't cite constitutional avoidance there. That never came up. There was no mention of the 10th Amendment, no suggestion that if Congress had in fact limited the power of the states to delegate authority there, that it would have created a constitutional issue. And the same conclusion follows here. There are also many other examples of laws that do sort of navigate the space between states and their localities. And that's why many of those cases are cited and statutes are cited in ours, Garage. Many of them are spending clause legislation, which presents a similar choice to what we have here. I mean, the whole premise of the spending clause is that states can choose whether or not to accept federal funding and the conditions that it comes with. And here too, the choice. They can choose to accept the federal default, or they can promulgate their own rules with the conditions that Section 1621D imposes. But I think what this sort of extensive analysis here of the meaning of the statute and the 10th Amendment shows is two central things. One, again, this is a federal case. This case is all about the meaning of Section 1621. And that, again, is why it does not belong in this court through a state law cause of action when Congress has chosen not to provide a cause of action, and allowing the claim to proceed here would conflict with Congress's choice. There are reasons why Congress chooses to provide or not provide for private enforcement, and that choice deserves respect consistent with all the cases we've discussed. And again, the complexity of the issues just summarized here would warrant a remand in the event that the court chose to reach the merits or found that it was necessary for a court to do so based on a reversal on the private right of action issue. If the court has no questions, thank you.
Thank you, Ms. Powell. Ms. Carroll.
Thank you, Your Honor. May it please the court, Catherine Carroll on behalf of the defendant appellees, Montgomery County officials. Ms. Powell, I think, well addressed the kind of practical issues that would arise in terms of conflict between a state court claim of the type that we have here and the purposes that Congress had in entrusting enforcement. And I won't belabor those, but I think it's important on the private right of action issue to note that there are, in addition to those practical considerations and the conflict between the state claim and the federal priorities, there are some, I think, even more fundamental structural principles that confirm the defect in the claim that plaintiffs are attempting to bring here and show why there is no private right of action here. And that really starts with Article 1 of the Constitution, which of course vests the legislative power in Congress. I think the core principle of the Supreme Court's private right of action jurisprudence is the recognition that it is a legislative act to decide not only what a federal statute says, but also whether that federal statute is privately enforceable. And so as the Supreme Court has recognized in Alexander versus Sandoval, and again more recently in Ziegler versus Abbasi, a court that allows a private right of action to enforce a federal statute when Congress has not done so itself essentially usurps that legislative power that is vested exclusively in Congress. And importantly, the Supreme Court noted that that's true, quote, no matter how compatible that private remedy would be with the federal statutory scheme. Structurally, it can't be done. And that principle is every bit as binding on state courts as it is on federal courts. Your Honors referred earlier to, there was discussion of the Supremacy Clause, and that's exactly right. That as a matter of the Supremacy Clause, state courts, of course, are bound by federal law. They must adhere to federal statutes as Congress has defined them. And they therefore cannot...
But counsel, I mean, that argument, if that you're making, and of course, would, if extended, bar a negligence per se claim when, again, back to the hypothetical I referred to another, if you have a negligence per se claim and the only standard that is at issue is the violation of a federal law or regulation for which there's no private cause of action, taking the argument that you're making now, that would make that improper too, and that's done all the time. So it seems to me we got, like we often have, some ambiguity when you have supremacy clause issues on the one hand and allocations of powers between two sovereigns on the other, and it seems to me the concept of preemption is the one is the issue that you have to figure out how those two interrelate. That's the deciding point. Am I wrong about that?
So, Your Honor, I don't think you're wrong that in the kind of case you're thinking of, whether it's a common law negligence per se type of theory or a statutory claim, something like the California unfair competition law, something like that, that I think that the analysis there is, as Ms. Powell was suggesting, a preemption analysis, and very often in those situations, a court might find preemption. I think what we have here that makes this case a little bit different, though, is that there is no respect in which this claim purports to enforce state law. I think this claim is actually much more similar to the Supreme Court's decision in Astra USA versus Santa Clara County in the following way. So Astra was the case, it was under the Public Health Services Act, which imposed statutory price ceilings on drug manufacturers, which in turn benefited certain covered healthcare providers. And those statutory obligations were incorporated into and reflected in an agreement between the government and the drug manufacturers. The plaintiffs were healthcare providers who wanted to enforce those statutory price ceilings. Everybody agreed that the federal statute did not contain a private right of action. So what the plaintiffs did was to frame their claim as a sort of common law third-party beneficiary suit to enforce or purport to enforce this agreement that incorporated the federal standard. And the Supreme Court said, no, you can't do that, because in essence, that is an effort to enforce the federal statute. And importantly, what was true in Astra and is true here, but is not necessarily true in the negligence per se and other types of hypotheticals, is that the sole theory of wrongdoing is a violation of the federal statute. And what the Supreme Court said in Astra is that when that is the case, as is true here, there is no meaningful difference. I think the court's language was that in substance, a suit to enforce the federal statute directly and a suit to enforce a purported state law claim that simply incorporates the federal standard is one and the same. And however the claim is dressed up, it's barred just as a structural principle, because it's up to Congress to decide whether the statute is enforceable, and there can't be an end run around that. And that's exactly the kind of claim that we have here.
So a negligence per se claim where the sole wrongdoing is violation of a federal statute, you would say is improper too?
So, Your Honor, I think where you have a state law that says public officials or other defendants may not engage in the following types of conduct. Certain conduct is unlawful as a matter of state law, or state law imposes a common law duty to exercise reasonable care, or state law proscribes, unfair business practices. Those are violations of state law for which state law can provide a remedy. And it might be the case that we look to federal law to determine whether that state law violation has been established. That is not what a Maryland taxpayer claim is. And I think this is a fundamentally important point about this case. Maryland taxpayer standing law is not a theory of liability. It does not define conduct that violates state law. It does not impose obligations. It is not possible for a defendant public official to violate state taxpayer law. All the state taxpayer doctrine is a standing doctrine that determines when a taxpayer has suffered a sufficient injury that he or she may go to court on behalf of a class of taxpayers seeking to enforce an obligation that exists under some other law. What Mr. Bakasha has referred to as an element of the state, of what he calls a state law claim, is not an element at all. Unlawfulness of the defendant's conduct for purposes of state taxpayer standing is not an element of a violation of state law. It is part of the definition of the injury that is necessary for the plaintiff to have standing. But what the plaintiffs are doing here, and this is crystal clear from the very first page of their complaint through all of their summary judgment briefings, through their briefing in this court, the one and only theory of wrongdoing in this case, just as in Astra, is that the defendants supposedly have violated federal law. There is no claim that any defendant has violated any duty imposed by state law. So all this case is, just as in Astra, is an effort to use a state law cause of action as an empty vehicle to create a right of action to enforce a federal statute. But it is up to Congress as a constitutional matter to decide whether a statute is privately enforceable in court. And as the Supreme Court has recognized, not only in Astra, but in the Section 1983 cases, Moore and Howlett, it is not for states to create rights of action directly seeking to enforce a violation of federal law. Leaving for another day whether if a state law were to incorporate as an element of state law the same standard, then I think, a lot of the same reasons would apply as Ms. Powell has suggested. And it may be, Judge Quattlebaum, that you get to the same destination through either route. But I do think it's important to understand the distinction between the kind of claim that plaintiffs have purported to bring here and the hypotheticals that you're thinking
so
of.
you don't think the Maryland legislature, for example, could say, hey, we're elected officials, we're going to create a statutory cause of action, and we think you can buy if a Maryland public official or a Maryland municipality were to distribute benefits in violation of 1621 and it causes injury to one of our taxpayers, we hereby create that cause of action. You don't think they could do that?
So, Your Honor, I think that the analysis there would be, I think, again, sort of two routes to the same destination.
Well,
one
just
would be
can you say? I mean, I wanted to let you explain, but sometimes last time I never got an answer at the end of it because you went to a different thing. Could you tell me first if you have an answer, whether it's yes or no, and if it's too hard to answer that, that's fine too. But I want to make sure I don't lose you.
I think the answer is probably not, but I also think that the answer to that question doesn't determine the answer to the case here. I think, as Ms. Powell was indicating, a claim like that would indeed raise serious concerns as a matter of conflict preemption, as in the Third Circuit's decision in Ray Commonwealth's motion, as in the Arizona and Buckman cases and so on, because you have a congressional decision to entrust enforcement authority to a single federal enforcer. And it upsets the federal state balance to change that scheme and to allow a patchwork of inconsistent state law enforcement of the same federal standards that undermines the federal choice that Congress has made. So we think that that would be very problematic. And what I mean to suggest is an additional problem, one that applies in spades in this case, which I think is a much easier situation than Your Honor's hypothetical, is the more sort of foundational structural principle that the more that cause of action starts to look like the cause of action in Astra, that is an empty effort to circumvent the absence of a private right of action in the federal statute, where we're simply seeking to enforce federal law without purporting to enforce state law, that I think is very straightforwardly not permissible. Again, because of the allocation of legislative power to Congress, which the Supreme Court said is undermined by an effort to create a private right of action where Congress didn't define one, regardless of whether or not having a state law remedy would or wouldn't be compatible with the federal scheme. So I apologize if that was unclear, and I'm sorry I wasn't being responsive.
No, thank you. I appreciate your answer.
But I think that we talked a little bit about what a state taxpayer claim is and is not in Maryland, and again, I think the Floyd decision and the State Center decision discuss this at some length and make clear that there's no substance to a state taxpayer claim in the sense of imposing any substantive duty or obligation. And I think the other thing that's significant about the Maryland court's discussion. I'm sorry, Judge Keenan.
Yeah, I'm Ms. Carroll. I'm trying to think about how one would write an opinion from your point of view, and trying to see whether it's overly simplistic. Is it overly what I'm thinking? In other words, is it overly simplistic to look at what body of law confers the substantive right, okay? And who is claiming protection under that right? And here, the plaintiffs are claiming protection under federal law, and they don't have anything really under state law by virtue of a substantive right of protection. I mean, does the access and the ability to challenge the legislation always follow who confers the substantive right, or is that too simplistic?
No, Your Honor, I think that's exactly right, and put better than I've been putting it. I think right that plaintiffs are seeking to enforce what they say is a violation of a federal statute. They're seeking a remedy for their own benefit for what they say is a violation of federal law. And so the question in that kind of a circumstance has to be, did Congress intend that federal statute should be enforceable by the plaintiffs who are seeking a remedy to enforce it? We think that's exactly the right question. And I think the way that I would answer that is to say, first of all, as Your Honor was adverting to earlier, there is absolutely no authority in 150 years of Maryland case law indicating that Maryland courts would permit this. And in fact, the State Center decision expressly acknowledges that whether a statute is privately enforceable is ultimately a legislative judgment, and that even a taxpayer suit can be precluded by statute. But okay, even if Maryland...
Yep, I'm sorry. But even, so if that concept works then, would you answer Judge Quattlebaum's negligence per se action question then by saying it's the state of Maryland that confers the substantive right of negligence as a common law right of recovery, and the federal statute is simply separate from that substantive right conferred by the Maryland statute? Or again, is that too simplistic?
I don't think it's too simplistic, and I think that's a good way of thinking about the negligence situation. I mean, in a common law theory, state law is imposing a common law duty. Let's say it's a duty to exercise reasonable care. And the state law might make a common law remedy available to a plaintiff who's suffered an injury that was proximately caused by a defendant's failure to exercise due reasonable care. That's a right that state law has imbued its citizens with, and a state law remedy for a violation of the state law duty. And it may be the case in a tort claim like that the evidence a plaintiff looks to establish that the defendant violated its state law duty to exercise reasonable care is, for example, the defendant failed to comply with, an FDA regulation about what the warning label had to say, for instance, on a drug or medical device. But the role that federal law is playing in the claim is that it is providing evidence or a standard by which to establish an element of a violation of state law that is a substantive right conferred by the state on its citizens. And that's what's missing here. Because again, this is not an effort to enforce or seek the protection of some substantive state law. It's an effort to invoke a federal statute. Yes, I'm sorry, Judge Quattlebaum.
Yeah, I mean, this is fascinating. I think this gets, a bit to the nub of it. And I guess why though, it seems like you're delegating or relegating Maryland taxpayer standing cause of action to some second class cause of action. because Maryland created that cause of action. And just like negligence is a breach of a duty, and the negligence per se is informed by a federal standard, which you say is okay, here taxpayer standing is the substantive right is to bring an action for unlawful activity. And why would you not, in effect, substitute unlawful activity for breach of duty as just different elements to different types of state causes of action?
I think the answer to that can be found in the state courts discussions in State Center and Floyd about what taxpayer standing is and what it is not. The Maryland courts have not purported to define taxpayer standing as proscribing any conduct at all. In a taxpayer claim, a plaintiff must point to some other law. Typically it's, a zoning law or, a law requiring single subject appropriations bills, or, the county is issuing bonds on subjects that it has no authority to issue bonds on under its county charter. The plaintiff in that kind of a claim must always point to some other body of law that imposes a duty or prohibits conduct as a matter of state law that the defendant has allegedly violated. And taxpayer standing does not do that. There's no such thing as a claim that a defendant violated the taxpayer standing doctrine. All it is a ticket to court for a plaintiff that can show a violation of some other law. And in 150 years of Maryland cases, there have been no instances of a Maryland court purporting to permit that kind of a claim to enforce any federal statute at all, much less one as to which Congress did not create a private right of action. I see that my time has expired. I'm happy to take questions if the court has further questions. But I think that the most straightforward resolution of this case is the path that the district court took. And the absence of a private right of action here is both the beginning and the end of the case. And we would urge the court to affirm on that ground.
So Ms. Carroll, just to sort of encapsulate, your position is that under Maryland law, a taxpayer can have standing, but may not have a cause of action.
Well, okay, so Maryland courts
No, that's my question. I said,
yes.
So your position is that you can have standing, but you may not have a cause of action.
I don't think I would frame it that way.
Well,
because
in part, I thought that's exactly what you said. It said there is taxpayer standing, but there's no right of right of action that exists or substantive prohibition that you can enforce.
Correct.
So isn't that the same thing? I'm just cutting to the chase.
So
why? No, I want to know this. Why is not my summary correct? Let's put it that way.
It's absolutely correct as a matter of federal law, which finally distinguishes between constitutional Article 3 standing.
No, I'm not talking about federal law. I'm talking about Maryland law. You represent
Maryland. That's why, because you framed it as Maryland law, that's why I think, to be a little bit more precise about it, we have to look to what Maryland courts have said about how Maryland courts don't distinguish between standing and cause of action in the same way that federal courts do. But that doesn't make a difference to the outcome here, because what Maryland courts have said over and over again about taxpayer cases is that taxpayer standing is standing, not a cause of action. In fact, those cases say you don't even have to point to a cause of action, because in Maryland, we don't sort of distinguish that concept. But certainly as a matter of whether and I think this helps to answer the question of, like, why is it that in 150 years, no Maryland court has purported to permit enforcement of a federal statute in this way? As a matter of federal law, it's not up to the Maryland courts to decide whether there is or isn't a cause of action to enforce a federal statute. So we can't dispense with the cause of action requirement to enforce a federal statute in the same way that a Maryland court might choose to do as a matter of Maryland law. Although again, in State Center, the court made clear that if the General Assembly made clear that it meant to preclude taxpayer suits, then the court would defer to that judgment, because ultimately the right to enforce a statute is a legislative determination, and a court can't supply a right of action under a statute any more than it can rewrite the substantive provisions of the statute. And that's especially true with respect to federal law. So I think that it gets a little bit complicated to distinguish it between those ways because of the different approaches that federal courts and state courts take to those concepts. And so I'm just trying to be, precise about how those terms are used and to respect how the Maryland courts have used them. I mean, certainly from the perspective of why this suit fails, it is because the plaintiffs here have it's not that there's an absence of standing or jurisdiction, there clearly is. The reason the suit fails is because this is a suit that does absolutely nothing but attempt to enforce a federal statute that Congress has said is not federally enforceable. And that is not permissible as a matter of federal law. Maryland courts have never suggested they would allow it, but even if they did, it would not make a difference because as a matter of federal law, for all the reasons that we've been discussing, it's not permissible and it's foreclosed for lack of a private right of action.
All right, thank you. Thank you, Ms. Carroll. Mr. Kasha, you have some time reserved.
Thank you, Your Honor. I think Judge Quattlebaum said it correctly that both the government and Montgomery County's attorneys are treating taxpayer claim as a second-class cause of action. It's not. The Maryland courts are essentially clear that taxpayer claims are essential substantive right that taxpayers of the state of Maryland have. The Maryland courts do not distinguish between a cause of action and standing here because a taxpayer claim is both the standing and the private right of action and the cause of action. The Maryland courts have specifically said that there does not need to be, the violation of law does not have to have a private right of action because this substantive right provides it. Counsel talked a lot about in 150 years, the courts have never said that the underlying issue cannot be or can be federal law. Well, Maryland courts have not said it cannot be. Maryland taxpayer standing focuses on whether or not local officials are spending taxpayer money unlawfully. That's what it does. What Montgomery County's argument is today is that Montgomery County officials can violate federal law, but they can spend taxpayer money in violation of federal law as much as they want, and taxpayers do not have a remedy in court to try and stop them from illegally spending money. That just can't possibly be the case, and Maryland courts have not said so. Now, we pointed to two cases.
Well, counsel, that would be the case, but for a state cause of action. I mean, that could be that you could make that argument about all sorts of things, and we'd have citizens running around as would-be attorney generals all over the place. It seems like the ballot box is the place that, as a general rule, would be the reason what you said is not true, unless there is a state cause of action. In other words, you got to have that, don't you?
You do, Your Honor, and we have that here. So I apologize.
Well,
a little bit of sloppy language on my part. We have that here, Your Honor. We have a taxpayer claim that's well recognized in Maryland, as it is well recognized in a majority of states. And in all those, Montgomery County and the federal government has not pointed to a single case in Maryland in which the courts have said that federal law cannot be the basis for the illegal action. And these are not second-class causes of action. These are well recognized and established substantive rights.
What is your cause of action outside of the cause of action?
The cause of action,
not standing, cause of action.
taxpayer claim, Your Honor. That's
A
under
claim of what? A claim of what?
A claim of illegality of in this case, it's they're spending money unlawfully in violation of the law.
The law is what law?
In this case, it happens to be the federal law, Your Honor.
Yeah, you don't. That's the whole point. You have to piggyback. I mean, it is quintessential. You have to have a federal statute. Now, you may have what exists, I suppose, and clear there's a standing as a taxpayer in Maryland, but you have to find the cause of action, or one at least as a private right of action allowed by state or federal government. Isn't that the issue here, really? You come back to a federal statute that you want to enforce, and I don't want to, preempt it because we're still trying to decide this thing. But the question is, do you have a private right of action established by Congress at all? Do you?
Thank you, Your Honor. As we've said, there is no private right of action under Section 1621. However, there is a cause of action. The taxpayer claim in Maryland is the cause of action. It's different than federal court. Federal court taxpayer standing is just that. It's just standing. In Maryland, it's different. And this is why counsel for Montgomery County had difficulty answering your question, because she could not say there is no cause of action here, because Maryland, the cause of action in Maryland is this taxpayer cause of action. It is all the elements of the claim of the cause of action is taxpayer, that it's on behalf of other taxpayers, that the government has taken action unlawfully, and that the result of the unlawful action is a pecuniary harm. Those are the elements to the claim, Your Honor. And one of those elements is illegality. In this case, yes, our argument is that the money is being spent illegally because of a federal law. And that's the same to a lot of the FDCA cases that this court or the district courts in this circuit hear quite frequently, where negligence per se claims are brought, and one of the elements is violation of law. And in that case, they point to the violation of federal law or federal regulation where there is no private right of action under the FDA Act or FDCA Act. And so these types of claims are common when it comes to negligence. This is a different type of claim, but it's still a real first-class cause of action claim under Maryland law. And it's almost ironic that Montgomery County is also arguing in this case, well, had Maryland created a statute that created this cause of action, that maybe then that cause of action would exist. So it seems as though Montgomery County also wants to argue, well, maybe the state needs to do it a certain way for it not to be preempted. And that's not the issue here. The issue here is the Maryland judiciary, Maryland law is that this not unique to other states, but unique to what is often seen in the federal courts, that taxpayer claims are both the standing and the cause of action. They're both pieces to it. It's not just the standing part like you see in federal court, and as I had discussed earlier about Article 3 standing in federal courts when it comes to state taxpayer claims versus municipal taxpayer claims. I hope that answers your question, Your Honor.
It does. Thank you.
Thank you. I see I'm out of time, so thank you for your time, and appellants would request that this court reverse the district court and remand it to resolve the merits. Thank you.
Thank you, Mr. Bakasha, Ms. Powell, and Ms. Carroll. Thank you for your arguments. I think as the arguments have shown, it's thorny issues here, and thank you so much for helping us wade through them. Can't come down and shake your hand, but know that we appreciate your presence. Very important, and it's good to see you, and be safe and stay well. And with that, I'll ask the clerk of the court to adjourn the court for the appropriate time.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.